Thanks. Mr Gregory, you're calling Mr Tudge?
I am, yes. The witness for today is the Honourable Alan Tudge MP.
Mr Tudge, will you take an oath or an affirmation?
An oath.
Right. Could you stand and that will be administered?
Response is I do. Please place your right hand on the Bible. Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Take a seat. Mr Gregory?
Yes, thank you, Commissioner. Can you tell the Commission your full name, please, Mr Tudge?
Alan Edward Tudge.
Mr Tudge, were you served with a notice to give a statement and produce documents?
Yes, I was.
Dated, I think, 17 October 2022?
I believe that was the date.
And have you prepared a statement for the Commission in response to that notice dated 20 January 2023?
Yes.
Mr Tudge, I see you have a paper copy of it there before you. Can I take you to page 57? There's no need to bring this up on the screen. At the bottom of page 57, the last two lines commence, I do not recall. You can see that?
Yes.
I understand you wish to withdraw that sentence or those two sentences from your statement?
Correct.
Commissioner?
So I do not recall the other cases from there on?
That's right, yes.
Okay. That's coming out, is it?
Yes.
Right.
At the bottom of page 58. That's a withdrawal that I accept, and it will be removed from the statement which is tendered online.
Mr Goh, that was the basis of your leave, I think.
It was.
All right, well, I'll withdraw the leave then. Obviously, if something pops up and you want to make an instanter application, you can, but for the present, you don't have leave to cross-examine.
Commission, please.
Thank you. Yes, Mr Gregory.
Thank you. I'm told it was only the second sentence, not the first, in that bottom of page.
Okay, I don't think it's too critical. But
Mr Tudge, is your statement with that redaction true and correct to the best of your knowledge and belief?
Yes.
Commissioner, it's convenient at this point to tender the exhibits for the day. There is a draft exhibit list listing exhibits 4621 to 4823. The document that was shown to Mr Yongan yesterday, which related to the radio transcript of an interview he participated in, I also tender. It will become 4824 on the updated list.
that was an ABC 24
Yes.
transcript. I forgot myself that it hadn't been tendered. Mr Solomon, I've just noticed that somebody's given me a witness and counsel list and you've got juniors according to it, but is that not right?
Mr Jeffries is in Brisbane. He's attending to some other matters this morning. He may attend this afternoon, but he may not, and so I didn't want to announce his appearance and find he wasn't here.
You know your own business. Thank you.
Thank you.
Yes, Mr Gregory.
Thank you. Mr Tudge, as you say at paragraph 3 of your statement, you were the Human Services Minister from 18 February 2016 until 20 December 2017. That's correct?
Yes.
And during that period of time, as Minister for the Department of Human Services, you oversaw the administration of various policies in a service delivery sense by the department.
The question meaning, is that correct? Yes.
Yes. And one of those came to be known as the Robodebt scheme, which attracted significant media and political attention during your period as Minister.
The OCI became, the online compliance intervention became to be coined by the Labor Party as the Robodebt scheme, yes.
One of the early briefings that you received after you commenced as Minister on 18 February 2016 was a briefing provided to you on 23 February 2016. There are 3 volumes of folders before you, and they contain the documents that I will take you to throughout the day. So if you wish to refer to the hard copy document, I can take you to a tab number.
That'd be good, please.
Tab 1 in Volume 1 is Exhibit 4621, CTH.2009.0006.2319.
On the exhibit list, that document is marked as 4623. Just check if your tab numbers are out or you've misspoken.
That's correct. There is an error in the tab number. It is behind tab 1 in the bundle, I think. You found it behind tab 1, Mr. Tudge?
I don't know what I'm looking for now, Mr. Gregory.
If you see the tab numbers down the right-hand side.
Yep, I'm at tab 1.
And is that the ministerial brief, or sorry, Department of Human Services Executive Minute?
Yep, received on the 23rd of Feb 2016.
That's it.
Yep.
Thank you. It is Exhibit 4623. The document is signed by you on 3 March 2016.
I presume so. It's been redacted, as you can see.
The signature's been redacted, but the date appears beside your title. The purpose of a briefing such as this is to bring you as the new minister up to speed with the topic or the contents of what's contained in the executive minute.
Well, yes. It means to inform me. It says that you note the information provided in this document, so that's correct.
Yes. The relevance of the document for today's proceedings deals with the question of the overpayment of social security benefits to various recipients and the budget measures which were then in existence to address that question of overpayments, you see.
That looks to be the case.
And if you go to page 2 of the document, ending .2320 in the top right corner, you'll see the subheading Current Budget Measures and Future Savings Possibilities,
yep,
where paragraphs 9 and 10 deal with the strengthening the integrity of welfare payments package of measures which was announced in the previous budget. See that?
Yeah, I can see that.
And it was identified for you by way of information that the savings set out in paragraph 9 flow from one of the 8 initiatives which involve data matching PAYG income declared to the department with PAYG income declared to the Australian Taxation Office.
In paragraph 10?
Yes, you see that?
Yep.
The point is, Mr. Tudge, you were informed at a very early time of the significance of the particular measure to the government's budget?
I was certainly informed of the budget measures, and I was aware of the budget measures from 2015, and that is a summary of one of them in paragraph 10.
Yes. And it confirmed to you that this particular measure, which became known to you subsequently as the manual PAYG measure, involved a significant number of interventions during the 15-16 financial year and an even greater number of online interventions during the 16-17 financial year.
That's right.
The information in paragraph 10 identified a significant business process redesign which enabled the increase in interventions from approximately 20,000 annually to 400,000 annually in the 16-17 financial year. And would that be the first occasion when you gained a degree of familiarity with or understanding of the PAYG measure which was conducted while you were Minister?
To my recollection, and certainly having at least scanned the 8,000 odd documents which you provided to me, I don't believe there was any document before this time. It was the incoming minister's brief, which of course is an important document which outlines what the priorities are for the government in that. And that included a specific briefing on welfare integrity. And in that briefing, it didn't specifically, from my recollection, go to this level of detail.
Can I take you to tab 3, ATO.001.695.6261, exhibit 4625. This is an email between persons within the Taxation Office the following day, that is the day after you received the Minister's executive minute, which purports to attribute a position to you in these terms by reference to a Mr Lumley at DHS. In the context of a meeting which was said to take place the following day, it is said of you that you were excited by the outcome of the monies recovered as part of the recent data matching activities. If I pause there, do you recall taking that view or holding that position?
I don't.
All right. The concern that was communicated was that you may want even more historical data, that is, back as far as 2000, to recover even more overpayments. Do you recall expressing anything along those lines to persons in DHS within that first week?
I don't. No. I would say that this is within 5 weeks of me becoming Minister.
Yes, that's right. Certainly it was a significant aspect of that is this measure, the PAYG measure, was important to the government's approach to a balanced budget.
Sorry, say that question again.
The PAYG measure about which you received the specific briefing the day before was important to the government's approach to a balanced budget.
I don't know if I had that knowledge at the time. I wasn't a member of Cabinet, and so wasn't part of the Cabinet decision in, April of 2015 to determine that measure and the purpose of that measure at that time. Sorry, go on.
No, that's all right. I didn't mean to cut you off if you had finished. Did you understand, though, from your role as a minister, that the government was striving for a balanced budget?
Of course.
Yes. And this,
I think the public understood that.
yes. And this measure...
It's a good ambition, as it always should be.
This measure represented a significant aspect of savings available for forward estimates, to your understanding.
It's in the context of the social services budget, which was at the time, I believe, $160 or $170 billion. It's what was the amount again? It was in the first document. I think it referred to the amount. So 900. Is it 800 million?
Yes.
So maybe 0.5% of the social security budget. So it's not insignificant, but it's not.
in relative terms to the social security budget, it might not have been significant, but it was, so far as a balanced budget concerned, a significant savings measure.
It's still significant.
Yes. Did you ever consider, as the note suggests, whether the PAYG measure could be extended to increase the prospect of savings for the department?
I considered it, as I outlined in my statement, when at one stage the Finance Minister, Matthias, who was Matthias Cormann at the time, approached me and asked if there were further opportunities within welfare compliance for financial savings. And also the Finance Minister is a very senior minister. I was a junior minister at the time, and as I outline in my statements, and I can refer to the paragraphs if it's useful, Mr Gregory, that I had asked my secretary that question, and my secretary subsequently provided some advice in relation to that, which I, from memory, communicated back to the Finance Minister, and indeed that was subsequently became the subject of new policy proposals.
More specifically, did you consider whether the data matching activities which founded the PAYG measure were able to be extended to earlier years, that is, earlier than the...
No, I don't at all recall that. So that's why, going back to the email which you've got up on the screen, I simply don't recall that. Now, the email I point out, Mr Gregory, is by Michael Brown, who, and I can see from his email, it's redacted there, but he's from the Taxation Office. So I don't know that name, I never would have dealt with that person's name. Judging by his title, which I think is clear on the screen, he's not a senior person within the Australian Taxation Office, a relatively junior person within the Australian Taxation Office, reporting presumably to two other people here from the Taxation Office as well, names again I'm not familiar with and presumably still relatively junior, and they've had a phone call from Ben Lumley, oh sorry I didn't mean to, that name is mentioned, at DHS, a name that again I'm not familiar with at DHS, and he's referring to a conversation which he had with DHS executives who apparently had a meeting with me previously and a further meeting with me tomorrow. So in that context, and with no memory of suggesting at that very early stage to say, oh, we should be going back further years, I just simply don't recall that.
That's right. I think, as I indicated, it was not an email to which you were a party, but it attributed a position to you potentially, and I'm just...
It did, and I'm simply pointing out that it's an attribution going through the chain of many people from a junior level, from a senior level referring down to a junior level in a different department, then across to a senior level, presumably again, in a separate department. That's all I'm pointing out.
Can I take you to tab 4 in the bundle? Exhibit 4626. RBD.9999.0001.0372_R. This was a joint media release from you and the Minister for Social Services, the Honourable Christian Porter, 2 March 2016, which referred to broadly the topic contained in the title of ensuring welfare integrity, and specifically 2 bills being introduced to the Parliament on that date to strengthen the integrity of the welfare system. One of those related to the removal of the 6-year limit on debt recovery. That appears to be within a relatively short space of time following the previous email on 24 February, to which you were not a party. In the context of that joint media release, are you able to say anything more from your memory about whether you considered extending the measure to earlier financial years?
Again, if I look at this press release, Mr. Gregory, this is in relation to introducing legislation. I mean, as you'd be aware, the legislative process is a lengthy one. You don't make a decision today and introduce legislation tomorrow. So I would be very certain that this would have gone through a cabinet process before I was even in the ministry. And with those decisions made, probably in 2015, and then the bills would have been drafted and then scheduled to be introduced, obviously on the 2nd of March. So this press release would have been announcing simply the introduction of what would have been effectively Christian Porter's bills. He had responsibility for the Social Security Act, which I assume was the act which was being amended here. And it's this press release, I think, is no more than summarising what the two bills do.
I'm not suggesting you were involved in any of the decision-making which led to the legislative process described in the bill, but simply that it appears that you had knowledge that the 6-year time limit on debt recovery was being removed by legislative process at this point in time, and in that context, with that knowledge, whether you considered that within your department the measure might be able to be extended to earlier years.
I don't recall considering going back earlier than, because this was in 2016, going back earlier than 2010, and my recollection is that we didn't go back earlier than 2010. I think 2010-11 we might have gone back to that financial year, is my recollection. But I don't recall that we ever went back further than that.
Thank you.
So I'll just leave it there.
If you could go to tab 5, please, exhibit 4627, cth.3061.0005.3510.
Sorry, tab 5?
Tab 5, yes. Again, this is an email to which you are not a party, but it attributes a position to you. It says that your position was that you were keen to announce the strengthening the integrity of welfare payments measure had achieved the first year saving expectations already, and you were keen for an announcement about that. Do you remember being keen, as the email says, to promote the measures undertaken by the department, particularly this one?
I don't recall this in particular, but it doesn't surprise me that if it's a measure of the government that you're hitting a milestone, that you might want to announce the milestone.
Announcing that you might have hit a milestone early, or the department of which you were the minister hit a milestone early, reflected well on you?
Like, as a minister, you're obviously promoting the government's agenda as a minister. These were... the decisions for all of these were made before I became minister. I'd only become a minister by that stage. What day was that I became minister again? 18th of February. So you're talking about a couple of weeks afterwards. And so it was an opportunity to say that this measure, which started 9 months earlier, 8 months before I became minister, was underway and being implemented and apparently on track.
Or even ahead of schedule?
And if it's a... even ahead of schedule, but certainly meeting the milestone which was announced.
And to your mind, that was worthy of, as you'll see in the next two tabs, a media release and the promotion of an article through a newspaper announcing the early achievement of the measures that the government had implemented before you became the minister.
Well, yes, I think we did put out I don't know if we did put out a media release on that. Oh, we did. I can see it now in tab 7.
That is it. What I'm suggesting to you, Mr. Tudge, and we can go to tab 7, exhibit 4629.
I don't have the second page of that. I've just got the first page.
I've only got one page as well, but it indicates media contact at the bottom, which would generally be the conclusion of it, I think. The media release under your name, the day after that email was sent, 11 March 2016, confirms effectively a media announceable, as it might be described, that the welfare compliance measures were ahead of schedule.
Sorry, that you asked me to confirm that the heading says welfare compliance measure ahead of schedule, yeah.
And the behind tab 6 is a media article from the Herald Sun, exhibit 4628, CTH.300.0012.7824, which perhaps if we just go to the second page, thank you. Various statements in the short article are attributed to you. You would agree with me, they are statements which paint the government's agenda in a positive light and reflect well on you also.
The overall I mean, I assume that those quotes are taken from the media release, which we don't have page 2 of the media release. If we, I assume those quotes are accurately taken from my media release, which I would have approved those statements.
Commissioner, I can indicate the document produced to the Commission contains only a single page, which is the exhibit. Mr. Tudge, are you familiar with the process in your capacity as Minister for the Department of Human Services of providing a media release in advance to a journalist together with some lines which have been approved by you and maybe some additional information for a journalist to be able to run a story?
I think every single minister uses that process.
I'm not suggesting there's anything improper about it.
Yes, Mr. Gregory.
No, that's okay. And it may be that that process explains why, although there are not specific lines attributed to you in the media release, the journalists may still have been able to have recourse to a document which did indicate the statements attributed to you which had been cleared by you according to that process.
Typically, if the journalist was quoting me, I would typically want to see from my office every quote that was attributed to me before I went to a journalist.
Yes. And speaking broadly...
And I don't know if this was directly given to this particular journalist in advance as an exclusive. Typically, if it was, it would say exclusive on the article, which it doesn't say. So I don't know whether that's how it was done on this occasion. It actually appears that it wasn't, that it's more that this journalist has picked up the media release.
Speaking generally about the attention to detail you paid in respect of media relating to the department and to your office, would you accept that you paid a very high level of attention to the detail of the media generated in respect of your department?
So the question was, did I pay a lot of detail to the media in relation to my department?
Yes.
You do pay attention broadly to the media as a minister. You can't be across everything if there's a lot of media, and with many outlets across the country, many online outlets, many blogs, etc. You just simply can't be across absolutely everything, so you do rely upon your team in your office to assist you in alerting you to significant media stories as well.
Two aspects of your reliance on systems within your office or within the department were firstly that you had a media advisor, just as every minister does, who had responsibility for drawing to your attention media of direct relevance to your role. That's correct? And that was done on a daily basis?
Typically, yes.
And you also had access to or were the recipient of daily, sometimes multiple times a day, emails from the department which circulated media stories relevant to the department's activities.
Yeah, I typically wouldn't be reading those stories. I mean, you're getting so much information as a minister, you're getting 100 and 150 emails a day just to your APH account, let alone to your human services account.
So the reliance then was primarily upon the media advisor?
Typically,
and
on your
staffers.
media and your staff.
Yes.
If there was significant stories which were breaking or developing that they might bring to your attention.
And in respect of at least that category of significant stories, and I'm talking here about the Robodebt scheme to avoid being too general, when there was a great degree of media scrutiny about the scheme, was it your practice to be closely involved in the detail of what the department was releasing and what was coming from your office?
No. I didn't always know what the department was releasing because I knew that they were releasing some information, and they also had a public spokesperson who was acting independently of me and to my knowledge of my office. And he was very prominent in the media, probably did a lot more media than I did.
You're talking about Mr. Yongan?
Yep.
What then do you say to the possibility of a process whereby the media department of DHS would get information from the business area, draft a document which would be forwarded to your advisors, including your media advisor particularly, for review, which would be forwarded to you for clearance and then back down the line for the department's media release?
For the department's media release, I don't recall a departmental media release coming up to me for review. If it's... I can't recall an instance of that.
Okay.
I'm not just saying it didn't happen, but I think it'd be unusual if it did.
In terms of your perception of the role of media while you were the minister, did you understand that the media can give a minister a boost in terms of presence generally, effectiveness, the appearance of doing a job well, but it can also be equally detrimental to those qualities or the perception of those qualities?
I mean, the role of any political leader, in particular minister, includes working with the media to communicate what the government's message is. It's a very important part of the role. It's an expected part of the role by the public and certainly by the press corps.
And you took that role seriously?
I took every aspect of my role seriously.
Mr Gregory, I think you might have got your media releases and articles out of sync, because that article on the screen is the 3rd of March. It comes immediately after the joint press release. But there's another one at tab 8 in my bundle at any rate, which comes immediately after the 11th of March.
Oh, that's quite right, Commissioner, yes. Sorry, Mr Tudge, I did get things out of order. You'll see the article on the screen, Cheats Cop Whack, was published 3 March 2016, which was the day after the joint media release with Mr Porter about the 2 bills to be introduced to Parliament that day, the 2nd of March.
Right.
I think I related that media release to related that article to the media release at tab 7.
Yep.
That the welfare compliance measure was ahead of schedule, but you'll see that in fact the article at tab 8, welfare probe claw back at 329 million.
Mm-hmm.
Exhibit 4630 follows the media release on 11 March 2016.
Yeah, it does. It's. I mean, I can't recall this. They're 2 different stories which are quite similar. One on the 3rd of March and one on the 12th of March. Typically, if a paper has already broken the story, then another paper wouldn't, unless they had new information. I can't see the new information there contained in the 12th of March story. I will point out as well that obviously I have nothing to do with the headlines.
Oh, no.
Typically, nor does the journalist that you're dealing with.
No, I was just identifying the article as
Yep.
being the
They
different.
both appear to be, just from scanning them now, related to that same information
That was
of the $329 million.
which was the subject of the media release on 11 March 2016, yes. Certainly by a couple of months into your time as Minister, you sought information from the department about compliance and debt saving proposals which could be introduced by you into future budgets or legislation.
There was 2 parts to that question. The first part, yes. The second part, no, that I couldn't technically introduce them because it would have to be introduced by the Social Services Minister.
The ones I'm referring to identified in part at tab 12, exhibit 4632.
Mm-hmm.
It's an executive minute
Yep.
for your information, which was received by the Departmental Liaison Officer in your office on 28 April 2016 and signed by you 4 May 2016.
Yes.
And it's quite a detailed document. If you flick through it, I appreciate substantial parts have been redacted to reflect various forms of privilege, but this was the nature of information you were seeking from your department in respect of savings measures which accorded with the government's narrative of welfare integrity.
That is correct.
And as we can see from the material which I've just taken you through, would you agree with the proposition that you really did hit the ground running? You were keen to know what was going on in the department in this area, and you were asking for new ideas?
As I indicated earlier, Mr. Gregory, these came about from a direct request from the Finance Minister. And so there was a process, and I've outlined this. I was just trying to find the reference in my statement. I can't locate it immediately. If you give me a minute, I could find the reference in my statement if that was useful.
If you consider it's useful to your answer, certainly take your time.
It may be page 32. We'll assist the witness.
Sorry, say that again.
The paragraph's not numbered, but page 32.
Right.
Last paragraph.
Yes, it is on page 32. Indicate there that as I said before, in early 2016, I can't recall the exact date, soon after I was appointed, I recall being asked by the Finance Minister whether there were further opportunities for welfare compliance measures. I asked the Secretary that question. She provided a one-page table indicating that there were opportunities effectively, and I recall that table effectively either different years that you can do welfare compliance checks on, or different data sets that you are able to match that had not been matched previously.
That is opportunities for budget measures which provided savings.
That's what the Finance Minister was requesting and was asking me specifically in relation to that question. So I asked the Secretary that, and she produced the documents. And as I said, the one specifically that concerns schemes which became to be defined as Robodebt was the NPP, which you see here, which you're referring to, which would extend the income data matching for 2 additional years. And it was actually the 2 additional years which were both the immediate past one and the immediate future one, which would become a past one in 12 months' time. So it wasn't going back earlier than had already been done, as in fact ensuring that the data matching was keeping up with each particular year. If that made sense.
Certainly. And at this time, that is April and May of 2016, you were aware that an election was soon to be called or was imminent?
Of course.
And as part of that election process, there were budget costings or projected budget costings which were announced by the Prime Minister.
There was a budget just before the election.
Yes.
So we all knew that the election, I think everybody within the who had any understanding of the parliamentary process knew the election had to be, I think the latest date was the 2nd of July, which I think was the date the election was held. And typically there's constitutionally there has to be 33 days, so you know the election is going to be called very soon. The decision in that year was to have an early budget.
And part of...
It wasn't an early budget, no. It was still a May budget, wasn't it? I can't recall.
Part of the election process, of course, involved commitments and policy positions by the then government in respect of what it would do in the future if it were elected.
Yes.
And one of those related to the department of which you were the Minister, and you'll see it behind tab 13. Exhibit 2889, ACS.9999.0001.0046, and you'll see the date at the bottom is June 2016 of the first page.
I would, sorry.
That's all right, you can.
No, I just would point out that the two things aren't related. This didn't go, those MPPs weren't part of the budget.
Yes, I understand that.
And so these were election commitments, not decisions of government. There was an MPP process. After the NPPs were developed, I don't know what happened to them. I was never involved in taking them to Cabinet, if indeed they did go to an ERC, to an Executive Expenditure Review Committee, or to a full Cabinet. I don't know. I was not involved. I don't believe they were. In fact, I'm quite certain they were, given that there's further evidence later on, post the election, that requested Minister Porter and myself to effectively bring these things back to Cabinet for authorisation, which had they already been decided in the budget context, you wouldn't need to do. So these were election commitments which were announced, but presumably off the back of the work which was done here.
And that's the point. The Finance Minister approaches you and asks if you can identify savings in your area pre the budget. The usual process is followed where you ask the department to see what can be developed for your information, and they provide you the document you've seen. In the context of the election, off the back of that document, you wouldn't be surprised to learn that an election commitment for better management of the social welfare system would be informed in part by the information that was contained with possible proposals obtained from the department.
No, I mean, I wasn't aware that this was going to become an election commitment. If that was your question, was I surprised? I didn't quite pick up the precise question. Sorry, Mr. Gregory.
Not at all. The election commitment, as you said, off the back of the document was prepared by the department at your request. I'm not suggesting it was prepared in anticipation.
Sorry, it wasn't prepared by the department. This was not prepared by the department.
No. And the policy proposal, the ministerial brief to which you've just referred, wasn't prepared at your request for the purpose of an election commitment. But the two are related in the sense that an election commitment which followed the development of the document by the department would be informed by what was possible and might be put into an election commitment for the future.
I think, yes, from reading this and understanding what was announced, it was very much based on the NPPs which had been developed.
Yes. And of course, once the election commitment is made, the pre-election commitment is made and the government was re-elected, the process of developing NPPs through the usual Cabinet ERC process ran its course.
That's correct.
But it highlighted, as the coalition policy document points out, the importance of savings under these measures within the department to the coalition's view to a balanced budget.
I think the savings were important, but it wasn't the only thing.
What do you mean?
I mean, welfare compliance is done in part for the savings, but it's also generally for integrity and to ensure that the public has confidence in the system.
Another part of it, of course, is that it's a policy which, although it has those two features, is also attractive to the government's political base.
Well, it tends to be attractive to the vast majority of the public, and that's the government's there to serve the public. And that's why over successive governments, going back to when data matching was introduced in 1990, the language of ministers and the press releases of ministers, the budget statements of ministers have been remarkably similar.
made an election commitment in the terms that this policy sets out on the back of proposals prepared by the department. The election commitment creates an additional hurdle for the walk back of measures which are later identified as unattractive or not working. Would you agree?
Because I'm not sure. Well, if the difference, are you making a distinction between had this been decided in the budget of May before the election versus it not decided in the budget and been made an election commitment?
Yes. The potential criticism for not following through on an election commitment is obvious in the political arena.
I accept that.
If you go to tab 14, exhibit 4633, this is a media release in your name as the Minister for Human Services following the government's re-election and your reappointment as Minister. You can see that?
Yes.
And if you go to the second page of it, you reiterate the announcement of measures or measures that were announced during the election campaign to crack down on welfare fraud and overpayments, and the continuing position of protecting the integrity of the welfare system.
Yeah, I mean, I would, if I may point this out, even to the Commissioner, this did not involve schemes which became defined as Robodebt.
No, what it involved was a policy position, as it were, or a policy statement by you about the work of the government in the area in which you were Minister.
I see what's saying here. Yeah. Welfare fraud and overpayments. It's a shorthand. I think that's a shorthand way of saying what the government's commitment was.
Yes. The task force integrity measure was, of course, to your knowledge, something which was established in the 2015-2016 budget and was up and running early in 2016.
Yes.
When you were appointed as Minister. But this press release reflects on the work undertaken earlier, essentially, doesn't it?
I mean, if you give me a second just to read the press release, I can't recall this press release. I mean, the purpose of the press release is pretty clear that it's effectively just announcing that there's a new head of Task Force Integrity. It's no more, no less than that. I'd be surprised if that got picked up in the media. May have done, but...
Again, out of sequence, but clear in the context of the election commitment, you understood the importance of the measures announced by the Treasurer, Mr Morrison, in terms of election commitments for savings. And I'll take you to tab 17. Exhibit 4636. It's an article in the Daily Telegraph, 29 June 2016.
Yes, I've got that document.
And you appreciate, of course, that as Minister, your role is to deliver on election commitments which relate to your department?
My role was to implement the measures which were announced.
Yes.
Yes, certainly to oversee the implementation of those measures. Oversee the implementation of the measures once they'd been through Cabinet. These were election commitments, there'd be a process. Once they'd been through the Cabinet process, yes, then it was my role to implement them. It would have technically been, I think, either probably more the social services minister's role in terms of taking them through Cabinet, and then the Human Services Department to implement those measures.
Do you recall speaking to the Finance Minister, Mr Cormann, about what is described here as the Coalition's election costings, which improved the budget by about $2 million in terms of forward savings following the election commitment?
Following the election commitment? No, I don't recall.
Did you speak to him about it beforehand? Did he check with you that this was achievable within your department?
I can't recall that, but he would have been informed by virtue of the NPP process because it goes to finance. So as I said and as I've outlined on what was page 32 and 33 of my statement, I was asked by the Finance Minister, are there any further opportunities? I asked that question to my secretary. There was proposals put up which I noted, and NPPs developed which I noted. And through that process, he would have seen those proposals. And by definition, they're developed by the departments with the rigour and the costings behind. And then finance would do the final costings to be approved, which was obviously his department. So he would have been absolutely aware of it. And I think my recollection was enhanced by viewing some of the documents where there was an email sent from my office to go to, I think, Ministers Porter and I can't remember whether it was Ministers Cormann or Morrison with those NPPs attached for the purposes of announcing during the election campaign, literally a few days before the election.
And that email from your office for the purpose of this announcement a few days before the election campaign, did that place on you, to your mind, a sense of obligation to deliver the savings?
No. As I said before, the obligation comes after the Cabinet has made the decision and finalised what the Cabinet was proposing to do. And then the obligation becomes on the Human Services Department, who has the authority from the Cabinet decision, and then obviously oversight from the Minister.
To go back in time then, did you feel a sense of obligation for what was approved by Cabinet for the 2015-2016 budget in terms of the savings from the strengthening the integrity of welfare payments measure while you were the Minister?
Certainly, I felt a very strong obligation from the beginning of 2017 to ensure that that measure was implemented better and effectively and in a manner which made it usable and reasonable to a recipient. To be honest, I was not concerned particularly about the savings at that point in time. Later, I was more concerned about just monitoring where the savings were at, so at least I could keep a tab. And in part, the savings didn't fall within my budget. The within human services, you're in charge of the expenses of running human services, but all of the savings as such accrue within social services.
Surely, though, you must have perceived or understood that if you could deliver the savings in the budget, you would be viewed by senior members of the party and the cabinet as being capable and effective.
A lot within human services is just assumed to occur. I mean, it's a massive organisation with all of these processes going on. And my experience, and I think the experience of most human services ministers, is that you get on with the business, and it's only when things go wrong that things get noticed.
One of the things that you didn't refer to, and we'll come to this in more detail, when you describe your focus in January 2017 on making sure that the program was better and more user-friendly, was the legality of it or the fairness of it. Did you at all focus on those questions in January 2017?
Two different questions there. One about the legality, one about the fairness. The legality questions, no, I didn't. The fairness question, absolutely.
Right. Did you ever see an advice from your department which confirmed in your mind that the scheme, the OCI scheme as it was described then, was lawful?
I never saw an advice, no, that it was lawful.
Did you ask for one?
No.
You were aware that there were questions about whether the scheme was lawful being asked in the media?
I know from reviewing the documents that you've provided to me that there were some media articles which questioned that. And that was in about January of 2017.
Certainly, given the potential for media to change the wind one way or another for a minister and for a department, and the fact that you took that responsibility seriously, it would have been a simple thing to ask for advice to refute, to provide a comprehensive answer to those questions.
It was in the context that there was a lot of media in relation to the scheme. So, like I recall specifically, well, I only recall it having been made aware of it through the discovery process, that there was an article from Peter Martin that was brought to my attention, and I think it may have been, it indicated that it was brought to my attention by Prime Minister Turnbull on the 7th of January. Now, that was when I was still overseas, or it may have been on the plane on the way home, actually. I was overseas with my family in the UK, at my family's house in the UK in Western England. So going back to your earlier question, actually, I was watching a bit of the media, but I wasn't across the intricate details of the media when I was with my family on holiday. And when I came back, was very much focused on the implementation of the scheme, because there was a number of issues which had been raised in the media, and there was a number of issues which I subsequently discovered which weren't being done well, and that was my intense focus in January and February.
I appreciate that you were intensely focused on a number of aspects of the scheme. At this point, I'm just interested in this question of legality.
Yeah.
You, of course, have a law degree. And
never practiced.
But when the question of lawfulness is raised in respect of a scheme of this size in the media, and an article particularly brought to your attention by the Prime Minister, it would have been an easy thing to refute the suggestion by simply saying, where's the advice, let's provide it.
I was aware at the time, Mr. Gregory, so that was brought to my attention, as I said, when I was either on leave or I was just about to leave my family in the UK to come back early and address these matters and really understand very deeply what was going on with this process. And that was in the context of many, many other newspaper articles which had appeared over the Christmas period. When I came back, I very quickly realised that, or had confirmed for me, that this was a program which had been through a cabinet process. And as you'd be aware, or perhaps not, but a cabinet process is a rigorous process which always has a legal overlay through it. So the department's lawyers, the social services lawyers, Department of Social Services lawyers, would have had to form a view that it was lawful. Then on top of that, the Attorney General's department has to form a view in relation to the legalities of this initiative. So I knew that. I also became aware, I think at that stage, that income averaging, which was the subject of the Peter Martin article, had been used for as far back at least as 1990. It was a regular part of the architecture of welfare compliance. It had been used for decades under successive governments. That was my understanding also. And then I further recollect, and again my recollection being aided by looking at those documents, one of which you're referring to in terms of those NPP documents, and again which is a further cabinet process with an NPP being developed for the extension of income compliance for those 2 additional years. And it expressly said in those documents that there was no legislation required. On top of that, I always knew that if there was legal issues, the department would have an obligation to raise things with me. So, given all of those things, weighing up one article in amongst many, many, many articles from a journalist who was a journalist against the top lawyers supposedly in the Commonwealth government, twice going through a process, once in 2015, once when I was minister in 2016, and the chief legal officers of the department not raising anything with me, the secretary not raising anything with me, which she would have a legal obligation to do so. It simply wasn't in my mind to inquire about that. And my focus, as I said at that stage, was very much on what was going wrong with the scheme, the administration of the scheme, and how should that be addressed.
To clarify one part of your answer, you referred to the legal obligation on the Secretary to raise something of that nature with you. You are referring to the Public Governance, Performance and Accountability Act?
I think I make a reference to that in my statement. I don't think I was aware at the time particularly where that derived from, but I did have an understanding that there was an obligation on a secretary to raise significant issues to the minister. And it's unfathomable for a secretary to be implementing a program which he or she would know to be unlawful. It's unfathomable.
The question of whether it's known to be unlawful or not, would you also say that it is unfathomable that a secretary would not raise with you where a real question was asked? I'm not talking here about a journalist, but where a real question was asked about the legality of the scheme by someone who would have expertise in the area, even if it wasn't within AGD, your department, or DSS.
Sorry, can you just repeat that question?
You gave evidence that it was unfathomable that a secretary would not raise that with you if she knew this.
No, that would not implement. My evidence was that it was unfathomable that a secretary would implement a scheme which he or she knew was unlawful.
Right. I'm asking follow-ups to that. Yeah. Is it unfathomable to you that a secretary would not raise with a minister, such as yourself, the question of legality, where a serious question was asked about it after implementation?
I would not expect, if I'm to understand your question correctly, I would not expect a secretary to raise with me, hey, you know, there's a question that this might be unlawful, full stop. The secretary had that question in his or her mind. She's going to solve that question before raising it with the minister. The secretary is not going to just come up to you and say, hey, I've got this big problem, which happens to be within the department. I haven't even thought about it. I'm just raising it with you to, you know, cause you anxiety. The secretaries, you reach the senior levels of public service in Canberra, you're very senior, you're very experienced, you're very good. And if they thought that there was an issue, they would have got that checked. Then if they discovered that there was an issue, that would be raised.
In June 2017, the annual conference of the Australian Administrative Lawyers Association was held.
Didn't attend that one.
I'm not suggesting you did, but 8 people, I think lawyers within your department did, and reports about that were sent to the Chief Counsel, Ms Musolino, and to your secretary. And at that conference, a paper was delivered by Peter Hanks QC. You might recall him as being counsel in the Masterton and Amato applications in the federal court, off the back of which the class action
I don't recall that.
occurred. His paper, his presentation, later a paper in the journal, raised a serious question in his opinion, presented to everyone at that conference about the legality of the scheme. Surely in those circumstances you would accept, given what you've said about secretaries addressing questions before they come to you, that steps ought to have been taken in June 2017 by the Secretary and Chief Counsel to assure themselves of the legality of the scheme.
I mean, I don't think I was ever aware of that conference or of...
No, but you've given evidence about your experience as a minister.
I know you're not saying that.
No.
Should they, if they go to a legal conference and an individual says this is unlawful...
Not just any individual, an eminent silk presenting a keynote speech at a national conference for administrative lawyers, of which 8 people from your department attend, and of which your Chief Counsel is informed and your Secretary is informed.
Right.
Yes. What do you expect your Secretary and Chief Counsel to do, given your earlier answer about your experience?
Well, my expectation is that it would make them inevitably contemplate what the advice was that was given and reassure themselves that what they were doing was still lawful.
And in a practical sense, where that opinion was presented by an eminent silk, how would that reassurance be obtained?
I mean, it's such a hypothetical because I don't...
Well, it actually happened.
I know it happened.
The scenario happened.
I know it happened, but I don't have the full context of it. I don't know the rigour of the paper. I don't know this silk. I don't know the name. I didn't know he did the Amato case.
You didn't study Fagan, Bowman, Hanks, constitutional law at law school? Certainly a book I had.
You're testing my memory now, Commissioner.
I think I probably have to remember further back than you, Mr. Tudge, and I can remember that textbook.
I don't recall that particular textbook, and I did do constitutional law. I did advanced constitutional law with. I do remember my professors, Professor Saunders and Professor Craven, but I don't remember the textbook.
Okay.
So I simply don't know the name. I'm not.
This is a Victorian still. You're a Victorian, aren't you?
I was never even admitted to the law. I didn't practice law. I went straight into business straight after law school. So I'm a Victorian, and
All right.
that's.
I don't think anybody's holding that against you.
Anyway, going back to
You're saying you've never heard of Peter Hanks QC. That's the.
Peter Hanks QC. I don't think I know that name. I'm sorry, perhaps I should know that name. And I apologise to Peter Hanks if he feels as if I should know who he is, but
All right. Now, Mr. Gregory.
Thank you, Commissioner. We were turning to a follow-up from your evidence about what you would expect if a secretary had a question raised with them. They wouldn't just bring it to you and make you anxious, but they are at a high level of the public service. You would expect them to address it with a view to solving the position one way or another and presenting information to you that was important or necessary. So in this circumstance, as I've described it to you, while you were the minister, and that occurred, what would be your expectation of your secretary and your chief counsel? Is it enough to just contemplate it?
I would have expected them to contemplate it, probably to speak with the DSS lawyers as well, Department of Social Services lawyers. They were primarily responsible, is my understanding, for the legal advice and the legality of the scheme because they had policy ownership of the scheme and DHS was the implementing body. I don't know if they did that and debated with the DSS lawyers.
My question's about your expectation.
But I think that, would that be my expectation? Certainly that they would contemplate it, that they would discuss this with the DSS lawyers, maybe even refer it to the DSS lawyers and say, you might want to look further into this because it got raised. And my understanding is that DSS, being the policy owners, were the ones that had would do the legal checks as such when taking the policy through a cabinet process or other process. So I think that would be my expectation, is that they absolutely should raise it with DSS and say, here's this paper, you need to take a look at this and take action in relation to it, whatever action that might be.
It would be taking, obtaining a legal advice either from DSS or externally in respect.
I guess possibly. I mean, I don't know what advice it already had, so it.
Okay. So
they may have already had, for example, that's why it's in part hypothetical, because they may have gone and sort of said, listen, you need to check this. And they may have well said, listen, we've already got legal advice on this. Our legal advice is sound. We disagree with Mr. Hanks. That's why I just don't know the full context. And I didn't know the full context in relation to the legalities. It just had not crossed my mind until I read about it in the newspaper, I think, following the federal court case.
You, of course, appreciate the significance of an opinion delivered in a public way in respect of a scheme of this scale at a relatively early stage of it. If we're looking back now, less about a year into the automated process. It's either a legal scheme or it's not.
So,
It's a big question, isn't it?
whether or not it's a lawful scheme.
Yes.
And it was, to my knowledge, by then 40 years into income averaging, which was the key bit which the federal court found was unlawful. And I imagine, I don't know that paper, but I can only speculate that Mr. Hanks QC, KC, would have also said that income averaging was the unlawful component.
One thing that might happen after that, which would be not unexpected, would be that you might get a briefing saying at a public conference attended by DHS legal staff, an opinion was expressed that the scheme was unlawful. You might get some questions about it. We can reassure you that we've considered the position and it's lawful and attached as a copy of our advice.
I don't know if that's reasonable because it wasn't a high-profile enough conference, right? I mean, there's conferences going on all the time about every aspect of government, and you're not constantly getting briefings on somebody said this at a particular conference.
It's a high-profile scheme.
By that stage, it was a high-profile scheme. So I don't know if that's a reasonable expectation, Mr. Gregory. I think if having contemplated it, raised it with DSS, asked DSS to assure themselves as well as the policy owners that there were still issues, then I would have expected it to be raised. Absolutely. If then they formed the view that there is something in this, then it should have been raised to Mr. Porter as the Social Services Minister and no doubt copied into me as the implementing minister.
And if those steps weren't taken, even that initial step that you consider was the reasonable response, that shortcoming is obviously a failing within your department for which you are responsible as the minister.
And I'm going on the basis of what you're putting to me, which I have no basis to question, that this person was a very preeminent silk, that the lawyers from DHS understood his eminence in this particular field, then yes, I would have expected a lot of reflection on what he had put to them and certainly have raised it with the DHS lawyers, maybe from Annette Mussolino across to the DHS lawyers to say, hey, we were just at this conference, this immensely eminent lawyer or Silk had raised this particular issue, you need to be looking into this. I think that's a reasonable expectation that I would have had in relation to this based on the facts which you have provided to me today.
Yes. And a failure to take that step is, of course, a failure for which you are responsible as the minister.
I don't know that you can say that.
Well,
I wasn't, to best of my knowledge, I wasn't even aware of the conference that was occurring, Mr. Gregory.
but you understand the concept of ministerial responsibility.
In the broad scheme that a minister is responsible for everything which occurs within or her department, yes. But to say the way that you put it then, I was responsible because the Chief Legal Officer did not speak to the Chief Legal Officer of the Department of Social Services, I don't think is right.
But surely that just falls under the broad umbrella of ministerial responsibility. Where there is a shortcoming in the department, the minister is ultimately responsible for that.
As I said, I accept the and understand deeply the Westminster concept of ministerial responsibility.
Does that mean you accept the proposition as I just put it?
I don't accept the proposition that I was responsible for an individual not making a choice to not raise a matter with her counterpart in a different department.
About a scheme for which you were responsible as the minister?
I was responsible for the implementation of the scheme.
Surely that means the lawful implementation of the scheme.
Yes, the lawful implementation of the scheme.
Is that a convenient?
Morning break. 2:45.
All rise. The Commission stands adjourned until 11:45. The Royal Commission is now in session. Please be seated.
Yes, Mr Gregory.
Yes, thank you, Commissioner. Just a matter of housekeeping. I'm reminded that part of Mr Tudge's statement refers to proceedings before Parliament by reference to Hansard. Those passages aren't redacted, but they are tended. The reference is tended rather than the content, just for completeness.
All right.
Yes. Mr Tudge, you, if I can take you to tab 18 in your bundle, Exhibit 4637, we're moving to the period now in November and December 2016 before you went on leave. The document it appears to be an internal document from the department, or at least it's described as though it sets out your request and the answers. The request is for information for an update on the achievement of savings from a suite of welfare compliance measures under the 2015-16 budget and MyEFO. And the senior advisor, that is your senior advisor, is said to have requested the following, and there are 3 dot points there. Your senior advisor at the time was Andrew Aston.
I think it was Mark Wood.
Mark Wood was a policy advisor. Your chief of staff
It was Andrew Aston.
Andrew Aston, and your policy advisor in this area was Mark Wood.
Yes, that's right.
Yes. And so the reference to senior advisor as opposed to chief of staff is a reference to Mr Wood.
I believe so.
Yes. The questions have been pulled out on the screen together with the short answers. Do you recall at this point in time, either from your memory or the review of documents prompted from your memory, that you were keen to announce the milestones of those measures as they were achieved?
I mean, it relates to the questioning earlier in relation to some of the earlier media that, yes, I was keen to announce when we'd achieved certain milestones. So I can't recall this request, but it doesn't surprise me.
Doesn't surprise you. Do you also recall at this point in time being advised by your staff or media advisor that it was good to get stories into the media about the scheme, which set the tone for how it might be viewed publicly as the level of interventions was increased from September through to December?
No.
Behind tab 20 is an article, Exhibit 4313, published in The Australian on 5 December 2016. The title is Welfare Debt Squad Hunts for $4 billion. Thank you. And you can see it's described as an exclusive.
Mm-hmm.
And if you turn to tab 19, you'll see a media release in similar language dated 23 November 2016, although it was published on 5 December 2016.
Yep.
And does that indicate to you, that is the reference to the exclusive, this was one of those processes where the journalist was provided with a media release?
It certainly appears that way, given that it's marked exclusive.
Yes. And perhaps some approval.
And I do recall this particular media release.
And why is that one significant in your memory?
Why is it significant in my memory? It was a significant story. I remember it being brought to my attention and had recommended to me, I think, that this would be a good story to get out to show what the government was doing in this area.
And as is the usual process, once a story like this is published in a paper like The Australian, it can generate its own media follow-up stories.
Sometimes it won't necessarily generate media in other newspapers, or
But radio interviews...
might generate radio.
Yes. And one of those I'm suggesting is, of course, behind tab 21.
Yep.
2 GB breakfast, 7:13 a.m. on the same day.
I don't recall this. I have this in front of me.
Right. Can I take you to page 5 of that document? It is Exhibit 4639. You'll see at the bottom of the page the question from the interviewer asks, how does a compliance intervention work? And these are now dished out at 20,000 per week, whereas before you had this automated system, you could only dish out 20,000 a year. And you go on to explain your understanding of the process at that point in time.
Yes.
You can see towards the bottom of page 7, and again, I'm not being critical, it's the usual process of things, but you identify the political angle of it, that you're recouping some of the money which goes back to Labor's years because they didn't have any of those compliance systems in place.
Mm-hmm. Yes.
And at the bottom of page 8, the interviewer suggests to you that it's a big job, but it's also a big ocean of money that's owed to the taxpayer. And it's a proposition or a question that you agree with at the top of the next page.
Well, and that's consistent with me saying it was a significant savings.
Yes. And as a matter of logic, the responses you give at this stage, this is pre-January 2017, reveal the extent of your information about how the system actually worked.
Yes.
That is, you might agree with me that your understanding of it was relatively limited.
Yes.
And that it was only in January 2017 when, as you say, you became intensely focused on the detail that you began to get much more information about the practical workings of the scheme.
Yes.
One of those examples is that you might recall being on an interview for Triple J Hack just before you went on leave in December 2017, where you were asked about the 10% recovery fee, and you said words to the effect of, well, that's news to me.
I recall that interview.
You do, yes? Yeah. I'm sure that we have a transcript of it if you've
got a transcript of it. I've familiarised myself with that transcript, and I recall the interview because I recall being annoyed with myself coming out of the, either off the telephone or out of the interview studio, in relation to that answer, because I knew it'd get picked up, because it was one of those things in a split moment. You asked a question, you're not quite 100% sure what the question was. And the way that it was phrased to me was a phrase that I was less familiar with.
The emails from staff within your office to the department within a couple of days of that interview indicate that no briefing or further briefing was required in respect of the recovery fee or the penalty fee. Do you recall also that you came to understand the circumstances in which it was applied following the interview?
I certainly do in January. So that interview, it's probably in, I know it's in one of the 8,000 documents, it may well be in these bundles, but from memory it was in very late December, just a few days before Christmas, and literally possibly even the day before I left to go on leave. And then on the day that I came back from leave, it was one of the issues which I began to understand in a level of detail, and made changes to the system in relation to it.
By the time you went on leave at late December, it's fair to say that there was adverse media in respect of the scheme which was developing momentum.
I think that's right. I haven't gone back and lined up all of the media articles to assess how big a volume it was compared to everything else that was going on, and there was a lot of other things going on. But my memory is that's right, that it started, the adverse media started from about mid-December and was developing, and then was significant between sort of Christmas and New Year.
Do you recall that on the day the article was published in The Australian, that you were interviewed by a Current Affair?
I recall the interview with the Current Affair. I don't recall it being on the same day of the article being published by The Australian, and they were two different... I don't believe it was a follow-up to that article.
No, but it was a reflection of the advice that you'd received to get the story out there about what the government was doing?
Yeah, from my recollection in relation to the Current Affair, if that's what you're asking about, my recollection in relation to the Current Affair, and I don't have notes in relation to this, and it's not, to my mind, in any of the thousands of documents that I've viewed, but it was in relation to task force integrity. And the reason that I say that is that there was some other media in relation to that on the same day or the next day, that there was a new location for task force integrity. And from memory, that was the pitch to a Current Affair, was that it was in relation to task force integrity, which was about fraud.
Yes, as I understand it, you're saying that the quote, "We'll find you, we'll track you down and you'll have to repay those debts," which was presented in the Current Affair program, related to fraud matters.
It was a direct question on fraud, a direct question, which was not covered in the program, which was asked of me directly. The question was, and I recall the question, what would you say to people who deliberately defraud the Commonwealth? And I gave my response in relation to that question.
Would you agree with me that the language related to fraud and the language related to compliance, that is, administrative overpayments which don't involve any concept of dishonesty and relate to mistakes or errors in an administrative process of reporting, became conflated and easily conflated?
That was not my intent. And if you look through all of my media transcripts and media releases from, and I think there are over 800 for the period of time that I was Human Services Minister, I was very careful in the interviews to talk about fraud and separate that to inadvertent, and I'd use that word. And you could find it many, many times in my media transcripts. But I said, unfortunately, some people deliberately commit fraud, but on other occasions, people inadvertently enter incorrect information. And I always made that distinction to the best of my knowledge. And that was important to me to make that distinction. Going back to the Current Affair did not make that distinction, and it annoyed me greatly because they led with that quote, and then the whole story was in relation to inadvertent overpayments, and so conflated the two.
It would have been relatively easy for you to issue a media statement, though, correcting the distinction, if it was particularly important to you.
It wasn't my practice. Probably still isn't my practice. you're doing a lot of media, and if someone says something that it's incorrect, even on a current affair, you don't necessarily issue a media statement in relation to it. I did do an interview. Now, that was late December. Sorry, that was early December, on the 5th of December. I think when asked about it from anybody else, I said exactly that. And I know in my next interview, maybe it wasn't my next interview, but a further follow-up interview, which I did, which admittedly is in early January, but a far more prominent interview in some respects, because on Radio National, it was at the 7:35 time slot, which is the key political interview of the day. And everybody in Parliament House and in the political circles understands that. And in that interview, I was specifically asked about that A Current Affair quote. And I said the following. Well, I said, well, you do go to prison for a criminal offence, and that is when there's a deliberate fraud. So there's been a mischaracterisation in relation to the Current Affair quote. When I said that, it was specifically in relation to fraud, not in relation to inadvertent overpayments. So I very clearly stated that then. Now, I would say, and it's some of my critics have deliberately used that quote since for 5 years. Deliberately so, knowing that it's misrepresenting me. If I went through my Twitter feed, no doubt I've tried to correct it on Twitter, and it is still being used in a manner which I did not intend.
If you talk about the Task Force integrity measure and a measure to recover inadvertent overpayment at the same time, chances are the press are going to conflate the two and the public are going to conflate the two, aren't they?
But, Commissioner, from memory, as I indicated, that A Current Affairs story was in relation to Task Force integrity. So it was set up for that purpose.
So it had nothing to do with recovering debt through the data matching program?
My recollection is that that was the purpose which I was seeking to go into A Current Affair to talk about, not in relation to inadvertent overpayments. So, and then of course, having viewed the story, they completely conflate it. In fact, they barely talk about Task Force integrity in the program. And the program leads with my quote, which then frames the rest of the program, which I was not happy with.
I was speaking more generally than the current affair program. If you talk about a fraud measure and a debt recovery measure in the same press release, in the same interview, you're just inviting that kind of conflation, aren't you?
I don't know. I mean, I know it has been a practice of successive governments over decades.
I'm not sure.
I'm not justifying that because that's been the case. In part because the systems and the processes do have some overlap through the data matching, which occurs initially. And of course, with fraud, there's additional measures which are taken. And I think that's why, well, A, that's why they're administratively connected within the department. And B, it's probably why successive ministers have always discussed them generally together.
But do you agree with the proposition I put that, which is you talk about them together, people are going to associate them?
Unless your communication is clear, and I always tried to have clear communication, then in relation to overpayments, and I had a line, I mean, I can almost still repeat the line because I said it so many damn times, that that unfortunately there are some people who deliberately commit fraud, and there are many others who inadvertently don't input their income information correctly.
Okay, well, your answer is that
so
it doesn't happen if there's sufficient clarity of communication. Is that fair?
I think that's fair.
Okay. Thank you.
Mr Tudge, though, you would appreciate that from a recipient's perspective, that is a recipient of a debt letter, where there's the potential for that conflation and the materialisation of that conflation in December, that from their perspective, they might appreciate that there is a potential fraud component to what is being communicated in a discrepancy letter.
In a discrepancy letter. So you're putting to me that when a recipient receives a letter from Centrelink suggesting there's a discrepancy, that because I've done an interview which mentions both fraud and inadvertent overpayments, that they'll assume that it's in relation to fraud by reading that letter? Is that the question you're putting to me?
Except for the last bit, not assume that it's in relation to fraud, but be alive to the fact that there may be an allegation of fraud.
The letter, you'll remember, says something to the effect of, we have these figures from the Australian Taxation Office. That's not what you told us.
And I had, as you know, Commissioner, I had difficulties with the letters which were being sent out, and it's one of the things which I really wanted to examine closely.
Mr Gregory's question?
I would have to look at that letter. So you're putting to me that the letter itself was suggestive of that, and in concert with interviews which I did, which both mentioned fraud and inadvertent overpayments, that together those two things would put into the mind of a recipient that it could be fraudulent.
I think Mr Gregory's putting it, but yes.
Is that essentially what you're putting to me? I'm just trying to properly understand that.
Well, the conflation of the two concepts,
Yes.
which in fact occurred in the media in December 2016,
With that one interview it did.
gave rise to, but it was a prominent interview. It was on a current affair.
It was on a current affair. There's several 100,000 people would watch that. That's true.
And
But it's not. They're not watching it every day. Not everybody listens to my interviews every day, Mr Gregory, either.
you would appreciate that the conflation of the concepts in the media at that time could give rise to the impression for recipients of letters that they might fall into the fraud category.
I think that people would honestly know whether or not they had committed fraud, right? If they...
But Mr Tudge,
they
isn't
get,
that saying...
No, if an individual gets a letter which says there's a discrepancy between what they had self-reported some years ago with what the Australian Taxation Office says, I mean, I think they're going to know themselves whether or not they had deliberately underreported. They will
Do
know.
they know that they're not being accused of fraud?
I mean,
There are two different things here.
yeah, and I mean, I can't see inside the minds of every recipient who received a letter. I just do know, Commissioner, which I'll repeat, is that I always made it my practice to differentiate between fraud and inadvertent overpayment, because they are two different things, and it's why I was annoyed by the current affair program, and even more annoyed that critics would use that quote continuously for the next 5 years.
I've suggested to you that it was an easy fix on your part, that you could put out something very clear about that, in addition to the statements you say that you made in the meeting. Please let me finish.
Sorry, Mr. Green.
No, that's okay, because this is the point that matters. Because you had knowledge of the actual percentage of fraud cases, and it was minuscule.
So,
That is, you could go further than saying, in some cases there is deliberate fraud, and in some cases there is this other category. You could actually say in your interviews, and we know that fraud represents 0.1% according to historical statistics in respect of this measure.
So there was a number of points which you were making. The first point that you were suggesting was that I should have put out a press release.
You've answered that.
And I don't think, from my media experience, that me putting out such a press release would have had the same impact as doing a current affair. I don't think any media outlet would have picked it up. Now, it might have been that the journalists would read it, but they wouldn't have picked it up, and certainly the journalists would have listened and heard my transcripts, because my transcripts got sent around to all the journalists in any case.
You may not have listened closely to the question, but it was whether you could have gone further in your interviews and other dealings with the media in what you said.
To that, so that was the second part of the question.
All right.
The first part, I understood to be concerning putting out a press release. And the second part, in relation to my media interviews, could I have gone further in terms of saying that fraud, which is a very small part, in hindsight, I probably could have. I mean, when you're doing media interviews, they're typically very short interviews. It's not like this process. You are communicating in shorthand, even doing a 5-minute radio interview, trying to communicate a lot of material quickly. But I'd accept that if I wanted to completely clarify, I could have gone further in terms of pointing out how small it was.
If it was important to you to maintain the distinction,
Yes.
and avoid the concept of collation, the best way to do that was to say, in 99.9% of cases,
Right.
this is not fraud. We're recovering historical overpayments because of administrative errors.
Yes.
Easy to do, isn't it?
At the time, that wasn't the formulation that I used in my media interviews. You do a lot of media interviews, you tend to come up with formulations which you repeat, and they were formulations which other ministers had used in successive governments. So I'm not disagreeing with your proposition, Mr. Gregory.
All right. I'm suggesting the reason you didn't do it wasn't just a matter of formula and phrasing that was consistent and familiar, but it was because the overlay of fraud made it more likely that people would engage with the system and repay the money.
I disagree with that.
There was a particular strategy to the process.
I disagree with that.
And as at 6 December, if you turn to tab 24, Exhibit 3804, you were provided with a table which confirmed the 0.1% figure that I've referred to.
Sorry, this is at
Tab 24.
Right. And which paragraph are you referring to on this?
Well, I just confirm firstly at the title, this is
sorry.
a brief to Minister Porter, which is copied to you.
Yes.
Yes, all right. And the purpose of it is set out in point 1, information on major categories of debt sources, methods of debt recovery. More information has been requested by the Minister's Office on a fuller list of debt sources and amounts, and a breakdown of amounts of debt recovered by method. Now, I will take you to the page which is attachment A, the table CTH.3001.0030.7082. It's the, I think on the electronic document it'll be the 5th page in. And you can see for the financial year 2015-2016, in the table at the top, the line in respect of the source of debt relates to fraud is 0.1% as a proportion of the total percentage of debt raised during that year.
Yes. So what?
So my point is you had actual knowledge of the very small proportion of debt cases, and it was an easy thing to say once you appreciated, as you did by that date, that fraud an administrative error were conflated, to build that into your language at every subsequent media interview you did.
And I appreciate the point that you're saying, and I accept that I could have built that language into my media interviews. I will point out, though, that, and I know you did point this out, but I'll just clarify as well, that this was not a brief to me. This was a brief to the Minister for Social Services. It was a for information briefing for noting, so it wasn't a decision, and I was copied in. Now, I may not have even seen, Mr Gregory, this brief, given that I was CC'd rather than it being a brief to me for signature.
But if you're going to talk about fraud on a current affair, for example, and that's what
Yes.
you went there for, would you not ask your department, so what are the stats?
I can't find, I would have asked for a briefing, I believe, but I can't find in the documents which have been discoverable for me any briefing note for that current affair story.
But this might be it.
No.
Okay, then you would have asked, but we just don't have it.
I suspect, because this was my practice, that if I was doing an interview, that I would want the facts and the figures in front of me.
Right, but it doesn't seem that you transmitted those facts and figures, assuming you had them.
I don't know what I said to the current affair journalists, and the way that those TV stories are put together is that you may do a 10 or 15-minute interview in your office with the journalist, and they will take 5 sentences out of that 10-minute interview and not necessarily give the full context. That's a risk you take with some of those types of programs. And in this instance, I was completely, in my view, taken out of context.
All right, well, your media releases are your own work. Will we ever find one of them in which you point out the extremely small percentage of fraud cases?
I would have to go and familiarise myself with what is several folders of media statements and comments. My practice, though, as I said before, was to clearly differentiate between fraud and inadvertent overstatements. But I don't recall, Commissioner, going that further step as Mr Gregory was suggesting, of pointing out that fraud is a very small component compared to inadvertent overpayments.
Right, thank you.
I don't recall that being a regular practice.
Mr Tudge, you raised the possibility that this was copied to you for information, and you may
Yes.
not have been specifically digesting the detail. Can I take you back to the email that it was attached to at tab 23,
Yep.
exhibit 4640? You will see at the bottom half of the page an email from Ms Dryden, who was one of the departmental liaison officers in your office.
Is tab 23, did you say?
Tab 23, yes.
I don't have a document in tab 23.
My apologies for that, but it's now on the screen. And here's a hard copy as well.
Thank you.
It's from Ms Dryden to Mr Markovic in the department, copied to Ms Harfield and Mr Thomas. The attachment or the subject is the brief from DSS, and it seems to have come from Ms Dryden to the department. And then at the top of the page, Mr Markovic sends an email to Ms Golightly where he refers to your senior policy advisor, Mr Wood, about the brief.
And that was in relation to that specific brief that we were referring to previously?
Yes. And you would accept that what is attributed to Mr Wood there, that he wanted some time to digest the brief, would be the ordinary process for a policy advisor when a brief is copied to you as the Minister. They would pay close attention to it and...
Sorry, say that point again. There would be...
Mr Wood, you would expect, would take some time to digest the brief that you were copied to. as is conveyed by the email.
It indicates from his email that he did that, but you get enormous volumes of material into a minister's office. So when something is CC'd on a for information, it's not something that you would spend as much attention to, obviously, versus a brief which comes up for decision for the minister to sign. I just make that distinction. It doesn't mean that in this instance he didn't read it closely, and this email indicates that he had paid attention to this brief despite that.
And that it was his intention to show it to you over the next day or so. The data set was for the financial year up to 30 June 2016. And
yep.
You may well be interested in regular reporting on the topic in the future. That accords with your recollection as far as your recollection goes?
I have no recollection of that, Mr. Gregory, I'm sorry.
Right. But again, nothing said there is remarkable to you in terms of ordinary process?
No, nothing sounds remarkable, no.
Right, thank you. In terms of the development of adverse media, I'll take you to tab 25, exhibit 4641.
Yep.
You can see that it is a press release from Andrew Wilkie,
yes.
6 December 2016, which has been attached to the departmental media distribution, described as a breaking news alert.
Mm-hmm.
And the complaint there from Mr. Wilkie in his press release had a number of features.
Yep.
At the bottom of the page, it was that the new IT system was spitting out incorrect debt notices. And he gave some information about that, and that if people, over the next page, if people could not prove the debt was incorrect, they had to pay up or risk a visit from a debt collector.
Yes, I see.
Did you come to appreciate when you returned in January and looked at the process closely that indeed those two criticisms were valid? Firstly, that incorrect debt notices were generated by OCI.
Sorry, you're putting to me that...
When you came back...
Yes.
...and informed yourself in detail about OCI, did you come to understand that Mr. Wilkie's criticism of numerous incorrect debt notices was a valid criticism?
It was valid in the context that there were instances where people had not had any reasonable opportunity to be able to clarify a discrepancy following data matching. And by reasonable opportunity, I mean that a letter may have been sent to an address where that person was no longer at. So they weren't even aware that there was a discrepancy from a data matching process. Reasonable by virtue of the fact that they were being asked to go onto an IT system and upload documents, and the interface of that IT system was not adequate. It was clunky, it was difficult to navigate. It was unreasonable because there was not a 1-800 number clearly marked on the letter. They were just three of the things which I identified very quickly, having returned from leave, and set about to improve.
I understand your evidence in respect of your focus on how the system worked for the recipient in January and your efforts to make the system work, I think better was your language,
yes.
From a recipient point of view.
Absolutely.
My question, though, relates to your understanding about the generation of debt notices by the system which were inaccurate.
So at that point in time, my understanding was that they were debt notices which were based on income averaging where the recipient had, in some cases, had no ability to even challenge that up until that point. No
How
ability
did that
to
affect the
respond.
accuracy? I'm just not following this. Why did challenging or not challenging make the debt notice accurate or inaccurate?
The way that the system was designed was that the onus was put on the recipients to provide the evidence of their income if through the data matching process there was a discrepancy between what was self-reported.
Yeah, I understand that, but you were being asked whether you're aware there were inaccurate debt notices being issued.
Yes.
Were you or weren't you?
I was aware, well, I was aware that the system, even from an income averaging perspective, had the potential to create inaccuracies. And I became aware of that in January.
Well, you'd have understood.
Certainly became,
Sorry, you go on.
I was certainly aware that where the recipient had no ability to provide updated information on the request of the department, that a debt notice could be given which was inaccurate.
But even if a person chose not to provide information, the debt notice would be inaccurate, wouldn't it? It wouldn't suddenly change the figures according to whether there was...
Well, you just don't know. So you can't, you don't know without understanding exactly what their actual income was across the course of the 12 months.
Well, that's the trouble, isn't it? That averaging would only work if there was a neat match between time on benefit and employment and the hours were regular. Correct?
In terms of a perfect representation of what the person earned each fortnight, yes.
Yes. So anything that averaged, whether or not the customer responded, was liable to produce an inaccurate debt notice.
It had the potential to not be a perfect surrogate of what their income was, and that's what it had always been used for over the course of what I came to understand going back to 1981.
Did you investigate the circumstances in which it was used?
I did, yes.
And what did you learn?
Well, in 2016, it was used in a manner which I wasn't satisfied with because of some of the problems which I've outlined, and there are many others which I went about leading a transformation to fix those systems.
But you seem to draw comfort from the fact it had been used in the past, and I'm just wondering what inquiries you made to find out how it had been used in the past. I'm talking now in 2016.
Sorry, so in 2017, that was one of the very specific questions that I had put to Melissa Golightly. And there's an email in the, I don't have it in front of me, but when I was overseas, sending an email to, there's a reference in the materials to a conversation which I had, and Melissa Golightly, who was the Deputy Secretary at the time, was relaying to her team the conversation that she and I had. And in that, it specifically says that I was keen to understand deeply what the difference was in the processes between what she described and what I've described in my statement as being the old process, the interim process and the OCI process. And she produced for my benefit, which we utilised on the 9th of January when I returned, just a one-pager which summarised those three. And in each of the processes, income averaging was utilised. I've also...
According to what Melissa Golightly was...
According to what Melissa Golightly informed me as the Deputy Secretary in charge. The Secretary was there as well for all of those meetings which I was having in January to fix the system.
You could see, because it's not that hard to see, the potential for problems with averaging to produce inaccurate results. Did you wonder at all how it was permissible under the Act in those circumstances?
For the reasons that I articulated previously, that did not cross my mind.
All right. Thank you, Mr. Gregory.
Thank you. Commissioner, Mr Tudge, can I just clarify the extent of your recollection about those meetings with Ms Golightly and Ms Campbell, where I think you said that they informed you that averaging had occurred for a long period of time?
Yes.
Can you give some more context to that? These meetings, where did they occur? Who else was present? How long were they?
Yep.
What sort of questions were you asking and what were their responses?
Yes, so this goes back, if I can take you back to, we're in December 2016. As you point out, there was some media has started to appear. I think even that Mr Wilkie's press statement was in December. Cassandra Goldie wrote to me on the 21st of December. And then between Christmas and New Year, despite me being on leave with my family overseas, I was keeping an eye on the media, and clearly the media had ramped up, and there was stories most days in relation to it. So I made a decision to return from leave early and leaving my young family, including a baby in England, behind to understand deeply what the issues were and go about a process of fixing up those issues if indeed there were substantive problems with the system. I sent an email from England before boarding the plane, which I know is in the exhibit somewhere, which outlined at least some of the data requests which I wanted to be prepared for when I landed so I could hit the ground running when I landed. I spoke from England to Melissa Golightly in relation to the process. And then for the rest of January and going into February would meet most days or every second day in Canberra, either in my office, in a parliamentary office or down at the Department of Human Services, to actually go through in great detail how the process worked. I was specifically keen, Mr Gregory, to understand at that stage a couple of things. One being how that process worked from the recipient's perspective. So I wanted to put myself in the shoes of the recipient and understand in micro detail where I could how that process worked. And I was underwhelmed with what I saw, to say the least, and I can come back to that if you like. And I also wanted to understand what was different between the old manual system, which applied up until the 1st of July 2015, to then going into what Melissa Golightly called the interim system, which was the PAYG manual compliance intervention, which falls within the definition according to the letters patent of Robodebt. To then, and that occurred from the 1st of July to the 1st July 2015 to the 1st of July 2016, and then that transferred into the OCI. I wanted to understand what was different about those three processes. And I was particularly focused on what was different about that interim process compared to the OCI. Why is that? Because the interim process had already been underway. It had started on the 1st of July 2015. It had been operational for 8 months even before I became minister. And it appeared to have been implemented smoothly. There was no noise in relation to that element, that interim process, the PAYG manual compliance intervention process. ACOS had not raised any issues in relation to it, and the briefs which I was getting, which I refer to in my statement, were indicating that it was on track and operating well. My mind then turned to, well, if that was operating well, apparently going smoothly, but when I was the minister, the new system was being developed called the OCI. And so what was particularly different about the OCI versus the PAYG manual intervention system? And that became my sharp focus, because it appeared that those changes were the ones that were causing the distress amongst recipients, causing the media outcry, causing ACOS then to make representations to me in relation to it. And those then was my focus, and that's when I discovered and uncovered a number of matters which were unsatisfactory. The way that the letters were written, the fact that the letters
Right,
weren't...
if I can stop you, I think this all started with you saying you'd been told that averaging had gone on for a long time in interviews or consultations or
Yes.
briefings from Ms Golightly and Ms Campbell, I think, and you were asked about those meetings.
Sorry, then there were written documents as well to that effect.
Right, but you were asked, I think, particularly about those meetings, when, where, what was discussed. So can you move
I'm
to that?
sorry, that's coming to then this point now then, if I may.
Thanks.
Commissioner. So when did they occur? From the 9th of January, I think I landed back into the country on the 7th or the 8th into Melbourne and flew immediately to Canberra. These meetings occurred every second day for the second or third day for the duration of January and going into February, either in my office, in one of the parliamentary committee rooms, or down in the department. Typically at those meetings was, always at those meetings was the Secretary, Melissa Golightly, often Andrew Aston, my Chief of Staff, Mark Wood, my Senior Advisor, and other senior officials from the Department of Human Services. What we discussed, I was leading the discussion. I wanted to know, as I was pointing out, Commissioner, what the differences were, and then B, and most importantly, I wanted to understand from the recipient's perspective what their experience was, to therefore try to uncover where the problems were emanating from. And that's when I went in and said, take me through from square one, from the data matching process to a letter being generated. All right, let me have a look at that letter. What happens to that letter? How do you know that they're there at the right address? And discovering that they didn't necessarily always know there was no use of registered mail. I insisted, for example, almost then and there, we must use registered mail so that we have surety that people are actually getting a copy of that letter. I went through the screens in these meetings, screen by screen, in terms of, well, if a recipient has to engage, how do they engage? At that stage, a person had to sign on to a MyGov account first before they could access the online compliance intervention internet interface, which to me just became another hurdle. Now,
Right, we seem to be hearing a lot about your views of the system, but I haven't heard very much about what they actually said to you, particularly about how averaging had been used in the past.
Well, I can refer, if I may, pull out a document then, which might assist the Commissioner.
Yeah, by all means.
So because I should say before doing this, there's two components. One, my focus was very much on the administration of the scheme and how that was administered. And my strong view was that the issues which had emanated came about because of the administration and the implementation of the online compliance intervention.
Okay, but we're back at your views, and you were going to produce a document that would tell us what you were told, I think, or help us to work that out.
I can, if I may refer just a moment. So it's cth.3001.0032.6616.
Perhaps we can get that up on the screen and we'll work out what it is then.
It's Exhibit 4665, Commissioner.
Thanks, Ms Ogendorf.
Tab 55 in your bundle.
Tab 55.
Thank you.
it's not, it isn't tab 55, but I do have a copy of it in any case.
What's the tab number? Because it might be the same as mine and it's not my tab 55 either. Did you say you had found it?
No, it's not tab 55 in my documents.
Okay, and you
It
haven't
might be
found
tab 58, my apologies.
it? Okay, yeah, it is
Yeah, it is tab.
58, I think.
Thank you. Perhaps I can interrupt your answer, Mr Tudge. I'm going to take you to this document in some detail, but my question really related to an exploration of your evidence that you were told that in meetings with the Secretary and Ms Golightly that averaging had been used.
Yes.
And I appreciate the intense focus you had in January and the regularity of those meetings that you had with the Secretary and Ms Golightly and others. And you came to understand the role of averaging.
Yes.
And I appreciate that you've dealt with it in your statement by reference to this document, and I will come to this document. But my question relates to what was said and who said it and how the level of assurance that they gave you about this.
The level of assurance that income averaging had been occurring for some time.
Yes. Which was what I understood you to say, that you were told that regularly in these meetings.
I was told that frequently in the meetings, and also my recollection, even from the other documents, is that it's mentioned in other documents as well.
I appreciate all of that, but
But I do recall, I recall having the telephone conversation with Melissa Golightly before I got onto the plane, which went through this, and she certainly informed me of this. And I can't recall the specifics of that other than me asking about how these processes worked and wanting to understand it. And she relayed that conversation in an email, which is either one of the exhibits or in the discovery system. I can't recall the precise language which was used, but I came to learn from them and from these documents that income averaging had been used for some time. It was certainly used in the PAYG manual compliance intervention and was additionally used in the OCI. I don't know if that answers your question, Mr. Gregory.
I might ask things more specifically,
Yes.
and that might be easier to address. When you returned in January and met regularly with Catherine Campbell, did you ask her, how long has averaging been used? And did she give you an answer?
I can't recall specifically asking that question in that manner, but I do recall conversations in relation to income averaging, and I think that is I'd have to check this. My recollection is that's reflected in my media statements as well, that my understanding was that this process was very similar to what had been used previously.
Undoubtedly, that was said by you in your media statements, and you might have taken it from me that we've extracted as many references to averaging that you gave.
Sure you have.
In the bundles. My question, though, relates to the source of your information and the confidence of it.
Right.
That's what I'm getting at here.
Yes.
Which is, of course,
At that time.
in January 2017,
Yes.
I understand that you came to appreciate averaging had been used for a long period of time under successive governments.
That was my understanding.
And I'm trying to find out how you knew that and whether you received assurance from Ms Campbell about that and Ms Golightly about that. Or did averaging just not come up in conversations with them in January once you got on the plane?
No, it came up in conversations in January in terms of it was part of the overall process.
It makes sense if you're analysing the detail.
I was analysing the detail between the old process, as I said, the interim process here, and the OCI process. So
and putting yourselves in.
I can't, and this, you're talking about it, I can't recall specific the way a specific conversation went precisely in relation to income averaging, acknowledging that this was over 5 years ago now. But I recall understanding that that was part of the process and understanding that this had been part of the welfare compliance architecture for a very long time.
Taking your last sentence in two parts, the first is you came to an understanding that it was part of the process.
Yes.
The material shows that you could have gained that understanding from letters from ACOS,
Yes.
articles in newspapers, the like. I'm interested to know whether you came to that understanding from Ms Campbell as well. Did she say, we get to this point, you're in the shoes of a recipient, and what in fact happens if you don't respond is we average your income? Did she tell you words to that effect, that that's the point in the process where it occurs?
Sorry, that was a different point then. Did I understand that was the point in the process under the OCI? Yes.
Which is different to... tell you that?
Yeah. Did she say to me it had always been used? Is what we were discussing?
Yes, but you gave your answer in two parts.
Yes.
Addressing the first and then the second. The first was you came to understand.
Yes.
Did you understand that from Ms Campbell?
That income averaging was being used if a person had not responded to the requests for information and provided evidence. Yes, I did understand that. I believe
from Ms Campbell.
I believe so, but I can't be sure. Certainly Miss Campbell and Melissa Golightly.
In the meetings of which they were both always present, as you've said.
Correct.
That information was conveyed to you unambiguously in those meetings in January by the Secretary and the Deputy Secretary.
Yes.
The second part of your answer was, and that it had been used for a lengthy period of time, was that also conveyed by them orally in those meetings?
Yes.
Without you being able to say which of them said it?
I can't recall which of them said it.
But it was an unambiguous statement of fact said in the presence of the other, if I can put it that way.
Yes, that's correct.
Right.
And I have no reason to this day to doubt the veracity of that, having viewed the thousands of documents in the discovery system.
And you understood, of course, that that question of inaccuracy arose in the context of the application of averaging in those circumstances.
My understanding was that most of the inaccuracies occurred because individuals either had no opportunity to respond or found it difficult to respond to be able to provide their evidence of what they had earned in those years. And when they didn't have that opportunity to provide that evidence, then a debt was issued against them. And that was not an accurate debt based on what they had in fact earned.
And you appreciated that the question of accuracy or inaccuracy was to be measured by the income they earned during a particular fortnight of entitlement?
Yes, I did understand that.
And that by averaging without reference to evidence of income earned during a particular fortnight, the question of inaccuracy arose?
So by reference to the fortnight, yes, it had the potential for an inaccurate debt to arise. I did understand that.
Well, it would just be luck if it actually coincided, wouldn't it? Unless somebody earned the same amount every fortnight, it would just be a matter of luck whether averaging gave them the same result as what they actually earned.
I mean, a lot of people do. I mean, most people, Commissioner, do earn the same amount each fortnight.
Well, in the public service they do. I'm not sure when you're on a benefit that that's really true.
Yeah, and many of the issues which arose, particularly but from those who we didn't have addresses for, which constituted a lot at the time, were people who were no longer on benefits, almost by definition. So they were earning income. So many of them may well have been earning regular incomes by that stage.
Well, by that stage, but that's not much good because you're going back to the past when they were students working 10 hours a week at McDonald's. That's the problem.
Yeah.
Right.
Just to take you up on that last answer, Mr. Tudge, because of the design of the system, it didn't pick up someone who hadn't worked during a financial year. It required a discrepancy by reference to earned income.
If in the year that is being audited, you had to have been earning money for it to be, in fact, you had to be earning above a certain threshold for it to be picked up.
That didn't sit well in fact with the rhetoric of dole bludgers and dole cheats who might be more likely to not earn anything in it all during the financial year and just rely on Centrelink.
I don't understand the question in the context.
Well, can I take you back to Mr Wilkie's letter, media release, tab 25. Mm-hmm. The second criticism he raised after the question of inaccurate debt notices was the obligation on people to prove the debt was incorrect. That is, to prove it was incorrect, to pay up or risk a visit from the debt collector.
Yes.
The question of who bore the onus to establish actual fortnightly income was one focused on by you in January, as you asked a question about it.
Yes, I did understand in January that the onus was placed on the recipient to provide the evidence of what they had earned. And I also understood, going back to that process map and what I referred to as the old process, the interim being the PAYG process and the OCI, that change occurred in the 1st of July 2015.
Pursuant to what?
Pursuant to a cabinet decision.
But you can't go changing onuses on the basis of a cabinet decision, presumably. What were you told about the basis on which people were being asked for this information? What legal basis there was for saying you have to explain this?
I don't believe that came up.
Because that's one of the mysteries to me, I must say. These were not notices under the Social Security Act.
And I don't have an answer to that, Commissioner.
Okay.
But, I mean, going back to Mr Gregory's point, though, in relation to when the onus changed, that was a decision of the Cabinet in 2015 and was a feature of the PAYG manual compliance system, was that effectively the department stopped at that point taking the initiative and calling employers and the like on behalf of the recipients, and instead asked the recipients to gather the information themselves.
Okay, at which point we're back to pursuant to what? And it seems to be a mystery.
I don't know, but again, if I point out, Commissioner, that was through a cabinet process, and in a cabinet process, there's always the legal overlay, both from the department as well as from the Attorney-Generals.
Well, the problem with that is you need to detail the process in the new policy proposal so that those giving any legal overview can comment on it. And have you any reason to think the new policy proposals ever mentioned A, averaging, or B, the basis on which people would be required to answer outside the provisions of the Act?
I was not in Cabinet then, I wasn't even in the Ministry then, and I don't have access to those Cabinet documents.
Okay, thank you. We do.
So I just simply don't know.
We've got a few minutes before the lunch break, Mr Tudge. Can I just give you a few propositions and take you to a couple of documents which reflect evidence that you've already given? Despite your focus in January 2017 in identifying the issues with the system which attracted criticism, and your efforts throughout that month and into early February to address those criticisms and improve the system from a user perspective, those two criticisms identified in Mr Wilkie's letter and others I'll come to were not addressed. Firstly, averaging was continued to be applied and carry with it the potential for inaccurate debts. You would agree?
Not from that point in January, it wasn't until it was paused until August of 2017.
But averaging was applied?
Subsequently, yes.
At every stage where the process was operational.
Yes, but
It may have been paused,
it was paused, as I said, it was paused in that period of time, so it wasn't applying then.
but averaging wasn't paused. That feature
Averaging
of the system which created inaccuracy wasn't removed from the system. Is my
Debts weren't being raised at that point using averaging between January and August of 2017.
All right. And the second feature, the reversal of the onus, if I describe it that way, that didn't change either.
That didn't change either. And I just point out, Mr. Gregory, that both of those decisions were decisions of the Cabinet, of which I had no authority to overturn.
Sorry, which decisions were decisions of the Cabinet?
So the decisions of the...
To continue averaging and to continue the onus.
That's right. So the decision to effectively to place the onus on the recipient was a decision of the Cabinet in 2015, and a feature of the architecture of the overall system was the use of income averaging, which of course was part of the Cabinet decision as well. So then in terms of what my authority was the implementation of the measures. I didn't have the authority to overturn the Cabinet decisions as such.
So what would be the process then if you came to the view that averaging was unlawful in January 2017?
Well, I did not come to that view.
But in terms of your authority, surely you could stop the system.
If I came to that view, I would have raised it with Minister Porter.
And then what, a Cabinet process is necessary?
If it was unlawful, the law obviously is paramount to a Cabinet decision. So if it was unlawful, it would have to stop, as occurred following the Federal Court judgment.
Right. And in order for you to direct your department to stop it,
yes,
that is, you have to be satisfied that it's unlawful, are you saying that you require an opinion to that effect, or are you requiring a court decision to that effect?
I wouldn't... I can't envisage... If it was found to be unlawful, the department would stop it because they have legal obligations to not implement unlawful acts.
Or continue them.
To continue unlawful acts. So it wouldn't require a directive from me, and I can't... So it would never happen that way. I would have got advice that it was unlawful. They would have already known if it was unlawful and put in place those mechanisms, I would assume. But again, those are hypothetical to me because I did not know that the situation was unlawful.
All right. Do I take it from that if you had reached that view, your authority didn't extend to saying the scheme should stop now?
If I personally reached the view that it was unlawful, based on an advice or multiple advices, I would have wanted to seek the views of the department in relation to that as well, and presumably they provided me with that advice. And then if it was deemed to be unlawful, I imagine the same process that was followed by the Cabinet in 2019 would have been followed, which was that it was very quickly brought to a close.
All right, I'll take you through a few letters. Tab 33, Exhibit 3013.
Yep.
Sorry. Tab 32, to keep the chronology correct.
Sorry.
Exhibit 4648. Minister's Office information request, and you can see it relates to debt cases directly liaised with the office of Mr. Andrew Wilkie.
Yes.
There are questions there. Question 2 is, how does the department apply income for online compliance intervention?
Mm-hmm.
And you can see that there is a response there.
If we go over to the page ending .4941, at the bottom of the page you can see point 2 and the question is repeated, and it continues over to the top of the next page. The answer from the department identifies firstly a discussion regarding the application of income for the OCI, which may have been something you discussed with the department, but it refers to a validation exercise across 1,000 customers by comparing debt outcomes of 2 scenarios when income was applied using PAYG data. That is the averaging process. That is when a customer doesn't respond. And 2, when income was applied using actual data for a period of employment.
Yep.
And the outcome of the validation was a 13% positive or negative variance in the debt outcome when applying the ATO data. You see that?
Yes.
Right. And the range of things that cause the variance are identified as including weekly variability of earnings, the correctness and start and end dates of employment, and the ideal outcome is for customers to engage so that the variance is reduced or negated.
Yes.
It identifies what flows if the customer does not engage. But particularly the third dot point is one which I take it informs your understanding in respect of the methodology. That is, the methodology is the same regardless of whether the income is supplied by the customer or we use income received from the ATO. The income is apportioned fortnightly aligned to customers' entitlement periods as per existing social security legislation. You see that? Right. And that memo answered, it seems, 2 of your questions in late December in response to what Mr Wilkie raised with you.
Yes, so this was, just to clarify, I don't believe that I met with Mr Wilkie. It looks as if my office met with him or maybe a member of his office, and this was a briefing note. From the face of it, Mr Gregory, it appears to be for a member of my office to meet with Mr Wilkie or his office. So I'm not familiar with this document. I may have seen it, but I'm simply not familiar with it. I don't have any recollection of it.
Right. If I might just have a couple of minutes, Commissioner, to get us to the new year in January 2017. Next tab, tab 33,
Yep.
Exhibit 3013. You've referred to the letter from ACOS in December 2016.
Yes.
And that is the letter to which you refer. And you can see in paragraph 1 they identified, to use their words, a false notice of overpayment generated by the system.
Yes.
By reference to the averaging of income over 26 fortnights and correlating that to receipt of income support. Right? They identify another series of difficulties with the system, but at least that question of accuracy was identified by ACOS as well. At tab 34, Exhibit 4649, was a letter from Senator Xenophon, dated, I think, 21 December 2016, where he outlines in the second paragraph that in the vast majority of cases that his office has been inundated with, when the complaints have been queried with the department, they found to be incorrect. And then if you go to tab 37, Exhibit 4645.
37?
Tab 37, yes. Sorry, 4652. You can see that an article appeared in The Guardian on, it seems, 23 December 2016, where a person attributed to be a Centrelink officer was saying only a fraction of the deaths in the welfare crackdown are genuine. And if I take you to tab 39, exhibit 4654, a letter I'm told dated 30 December 2016. You'll see it at the top of the second page.
Yes.
From the National Council for Single Mothers and Their Children, also wrote to you identifying difficulties with the scheme at that time. You'll see in the first paragraph one of the issues identified was that the letters did not contain how the debt was calculated. And that in sub-paragraphs 3 and 4, the body sought that you undertake a manual review or direct a manual review to substantiate that the information is correct. There was a particular issue identified in respect of the automated system.
Yep.
And that subsequent correspondence should state how any debt or overpayment has been calculated. Can I just pause there? On point 4 in that letter, you would agree that where a department sends a letter to a recipient saying that they had a debt, it really should, as a matter of fairness and transparency, set out how the debt or overpayment had been calculated.
I think in the from my memory, the previous letter, which says that if you don't respond and provide this information, we will use ATO data to apply in this particular manner. I think it's outlined in that letter, but I don't disagree with you that it could be also outlined in the debt letter.
Well, the discrepancy letter to which you refer doesn't say anything more than this is what you've earned and it's different to what you told us.
I think in the latter iterations, and you're testing my memory here, that it did say what the consequences would be if you didn't respond to the request for evidence. And my memory, and I'm sure you can check this, is that it does say that if you don't respond, then ATO data will be used in an averaged way.
That in itself is a mystery, isn't it? If you have no idea how it's going to be used.
I'm sorry, Commissioner.
Well, just saying the ATO data will be used if you don't understand that it's going to be averaged.
I don't have the copy of the letter in front of me to know precisely what the language was. I made a very big effort to ensure that each one of these letters was tested with recipients. It was one of the clear things that I did in January, and not just actually these letters tested with recipients, but every single one of the 120 million letters which goes out from the department each year, that all of those batches would be tested with recipients properly before they went out so that it was properly understood, because I was concerned that there was a misunderstanding of what they meant.
Well, it's certainly the case that no letter, discrepancy or debt letter, follow-up letter, reminder letter, debt overdue letter ever set out. You told us you earned X during this fortnight, Y during this fortnight, and so on. And the ATO data averaged over those fortnights is a different figure, and we're relying on that if you don't respond.
No, I don't believe it did that.
No, and that would be the most transparent way to identify how debts were calculated.
That would have been a transparent way, yes.
Convenient time. 2:10.
All rise. The Commission stands adjourned until 2:10. Royal Commission is now in session. Please be seated.
Yes, Mr Gregory.
Thank you, Commissioner. Mr Tudge, I wanted to complete the topic of the interaction between yourself, your office and ACOS.
And sorry, and who?
Sorry?
What was that last word you said? ACOS?
ACOS.
Yes.
If you could turn to tab 184 in your bundle. It is Exhibit 3064. Mr Tudge, you'll recall that you met with Dr Goldie and Ms Crowe on the 19th.
Can you just give me a second to find that?
Of course. It might be in the second volume.
Should I familiarise myself first, or should I listen to your question?
Let's start with my question. You'll recall meeting Dr Goldie and Ms Crowe in your office on the 18th of January 2017?
Certainly in early January. I don't recall the precise date, but yes.
And that following the meeting, ACOS issued its own media release? Or a reference to the meeting?
I believe so.
There was a media article, which... Okay. All right. I'll take you through the documents. The one before you is tab 184, Exhibit 3064.
Yes.
Ms Crowe is the author of the email to Mr Wood, your advisor.
Yes.
Which refers to or conveys that ACOS will be doing media interviews that afternoon about the scheme, reiterating ACOS concerns, including those outlined in the 21 December letter to which you've been referred, and yesterday's meeting with you. The next sentence says, we took from the meeting that the Minister will consider refinements to the scheme but will not halt the automated debt recovery program and will consider our call to work with key stakeholders to redesign a system of debt recovery. Was that your recollection of the effect of the meeting?
Not that we took from the meeting, if I could take each part of that sentence, which I think you're asking me about. We took from the meeting that the Minister will consider refinements to the scheme. Those refinements were already underway, including almost every element in the letter which Cassandra Goldie sent to me on the 21st of December. And I've referenced that in my statement, as you'd be aware. So there was a number of points in that letter, and I methodically went through those. So it was underway rather than will consider. Absolutely underway, was happening. And then the second part, will not halt the automated debt recovery program. In practice, we did do that. It did halt until August 21st, when it resumed.
Did you convey to them that the program would not be halted despite what you say happened in a practical sense?
I can't recall a precise conversation, but I don't believe I would have said that so categorically. I would have been listening in carefully. I would have been communicating the changes which had either already been made in the first 10 days that I had returned from leave or were about to be made.
Can I take you to tab 185, Exhibit 4732? This is a letter from Dr Goldie to you.
Yes.
On the same date. You'll see in the second paragraph that ACOS called for an immediate end to the automated recovery program and for the government to convene a stakeholder roundtable.
Yes.
Does that assist your memory of the meeting the previous day in which Ms Goldie conveyed that request that it be stopped?
It does not surprise me. I cannot recall the meeting, but I would be very surprised if Ms Goldie had not said that in the meeting, that she requested for the what she called the automated debt recovery program to end, and that she called for to convene a stakeholder roundtable. Certainly the second part was contained in her letter of the 21st of December. The first part I don't think was, but as I said, it would not have surprised me at all if she did say that.
The dot points at the bottom of the page reiterate the deep concerns as described by ACOS and again, none of those are a surprise to you in terms of the nature of the conversation or the matters that were discussed with you in the meeting on the 18th.
I don't know if she raised these or not. She may well have done. It doesn't technically say in this letter that she did raise those in the meeting, but I'd have to go back to her substantial letter, which was at tab 33, which you raised earlier. That does go through in detail in terms of their substantial concerns, of which she documents 8. Does the reversal of the onus of proof. I don't think that was raised in that particular letter, though, in terms of that first one.
At the top of the second page, Dr. Goldie refers to the further various serious allegations released by Get Up today and asked you to support an independent investigation into those allegations, which of course related to a Centrelink whistleblower. Do you recall having those allegations drawn to your attention?
Vaguely, I recall those allegations being brought to my attention of a person who purported to be a whistleblower, but I can't recall the details of what the allegations were. But I do recall the concept of a person who was purporting to be a whistleblower.
Okay. I might take you to it. If you go to tab 190, Exhibit 4736, and tab 191.
Yep.
The Exhibit 4736, which is on the screen, is your email to the Secretary, Ms Campbell.
Yes.
The attachment is whistleblower document, plain English summary, and the message is please call to discuss.
Yes.
Obviously, it was a matter of some urgency to you.
I haven't familiarised myself with this document again. There was certainly, it appears to be of some importance to me to want to have a discussion with her. And I may have tried to get her on her mobile phone previously and without success, so sent her an email.
The attachment is at tab 191. Exhibit 4737. You'll see the title is the same as the attachment.
Yes.
It's not clear who the author of this document is, but can I take you to the page ending .5441? There's a heading, not checking existing evidence.
Yeah. Yep.
which asserts that Centrelink officers are not allowed to check the results of the automated system against evidence previously provided by the person or their employer, like payslips, medical certificates, etc. Can I take you then to tab 192, Exhibit 4738, which is the original document from which the plain English or layperson's version is drawn. This is the material published by GetUp from the person, as you described, who purported to be a Centrelink officer. If you go to the page ending .695, you'll see the top of the page has a subheading quality checking, and you'll see in the middle of the page evidence already on the system. Perhaps if that could be withdrawn and evidence already on the system could be called out. Thank you. You can see the assertion, we are not permitted to check what verification has already been provided by a customer. And see the categories there are in greater specifics than the summary, which was attached to your email to Ms. Campbell. But the first category is that evidence that a customer was not working, including medical certificates, notices from employers confirming termination, notices from employers confirming non-employment, and no leave payments during certain periods, etc. Do you recall from your conversation with Ms. Campbell whether she satisfied you that the complaints raised in this document about the limitations placed upon Centrelink officers were not valid or accurate?
I can't recall the conversation with Mr. Gregory in relation to this. Undoubtedly, if I asked for her to call me in relation to it, she would have called me.
Yes.
I do recall broadly not knowing who the person was, and you can never, in government, my experience is there's always so many people purporting to be somebody with inside information that you can't always verify whether or not it's an accurate whistleblower or whether or not this is somebody else. What I can say, though, in relation to the substantive points which are raised in this exhibit in terms of a compliance officer is that that was put in place. So the next time the debts were effectively raised, which was back in August of 2017, because I paused as we discussed before, there was then a compliance officer in place checking before the debts was raised.
Well, as it's phrased here, it indicates that already, doesn't it, that a compliance officer was in place, but they simply weren't permitted to check these categories of documents.
Okay, well, I've read this quickly for the first time, and my quick reading of it was that, and this because this was the discourse in relation to the program, that compliance officers weren't part of the entire program, it was all automated.
Yes.
So that's how I interpreted
in any event,
what this person was saying.
Can I take it that the effect of your evidence is, because this came to your attention and you asked the Secretary to call you about it, that you were concerned that if the substantive content had some merit, that it be addressed in terms of how the system operated?
I simply can't recall. I would have asked about it because it probably, well, I can't even recall why I asked about it, other than this was brought to my attention. Perhaps it was brought to my attention in a prominent article. I was very focused on the OCI at this stage. We're what is it, 10 days? I'm 10 days into returning from leave, and laser-like focus on this program in terms of trying to understand it and improve it. And so when this came through, supposedly from a person who purported to be from inside of Centrelink, then yeah, I took notice of it. I will say though that as important as this was, and I wasn't dismissive, I don't believe, of it, I did also engage with other Centrelink officers in January. It was part of my consultation process, was deliberately to go out and meet with those officers who were doing the frontline work and understand from them what the experience was, what suggestions they had.
Okay, I might, in view of that answer, go to another document, which you probably won't be aware of, but it relates to dealing with Centrelink's compliance officers and the information they had. If I can have Exhibit 2532 brought up on the screen, cdh.2009.0007.5968_R.
Am I able to get a hard copy of?
I'm not sure that anyone in the room will have a hard copy. We might all have to work off the screens. Mr. Tudge. By way of introduction to this email, you can turn to tab 193 in your bundle. It's not necessary to bring it up on the screen, but it is Exhibit 2531. You'll see that it is
193.
193.
Sorry, wrong file. Yep.
You'll see that it is a message from the Secretary, Catherine Campbell, to her department, Wednesday, 25 January 2017.
Yes.
At 3:54 in the afternoon.
Mm-hmm.
See that?
Yes.
Presumably daylight savings time. And it introduces, by way of introduction, says, you will have read a lot in media reports about our compliance process, and it goes on to thank the staff and speak generally about the validity of the process.
Yep.
An information letter to staff to trust the process effectively. And on the same day, there is this email sent from Ms Taylor, who you can see is a compliance risk branch officer, to the Secretary and Mr Yongan, and it has a number of attachments: response to the Secretary, PAYG rapid response prompts and in-confidence emails from January 2016. We go to the attachment, which is Exhibit 2533, cth.2009.0007.5969_R.
And which tab is that, Mr.
Again, this is just online. And we go to the, you can see there in the title, response to the Secretary. It is the first of the attachments to the email from the compliance officer to the Secretary. And if we go to the third page in...
So who's this? Can I ask who this is from?
Colleen Taylor, the compliance officer who was the author of that email.
Right.
Yes.
So she wrote this email to Catherine Campbell, is that what you're saying?
That's right. I'll give you a little bit more detail. Catherine Campbell sent out the general message to staff on the 25th.
Yep.
About, well, it was 6 days after the purported Centrelink officer raised concerns through Get Up in the media, and you spoke to Ms Campbell about it.
Yes.
And after Ms Campbell sends her message to the staff, effectively conveying that the system should be trusted, despite what might be in the media, a compliance officer called Ms Colleen Taylor wrote directly to the Secretary to correct statements that she had made.
Yes.
And if we could go to page .5972. One moment. Oh, sorry, you'll see the second paragraph. If that could be called out, thank you. Now, she qualifies the information you see by saying she was not involved in OCI, but was a quality checker in the rapid response team. But in January 2016 was advised that if a customer did not respond to the letter, we were to apply match data and not interrogate the customer record.
Yep.
So that even though there may be an employment separation certificate on file to confirm all earnings were prior to grant of Centrelink payment, we would erase the debt. You see? Yes, all right.
And that did not occur from that point onwards?
Sorry, from
that point onwards, there was a compliance officer. So the debts were paused, as I said, until the end of August. And at the end of August, there was a compliance officer there to do that checking, precisely dealing with the matter which she raises.
Okay. To be clear, what is raised here is the process as it was in the PAYG manual compliance intervention process, January 2016?
Right, sorry, yes.
Yes.
That effectively became the same process for the OCI.
That's right. And then if we move forward a year from the instruction given to Ms Taylor, we have a purported Centrelink officer in January 2017 raising the same issue, that they're not permitted to interrogate the customer record for information which indicates that someone might have stopped working at a particular point.
Yes.
And you speak to Catherine Campbell about that.
Sorry, so this point, you're referring back to then the whistleblower's letter.
Yes.
And saying that's on page 3, going back to that, the Centrelink officers are not allowed to check the results. That's the point.
That's the point, yes.
You're making. I can see that, and certainly from that point, as I indicated, that practice didn't occur again.
That was a little tangent partway through Ms Goldie's letter of 19 January, which referred to the information published that day, that is the serious allegations released by GetUp. Just to bring us back to where we were.
Yes, right. Can you bring me back to the letter of Ms Goldie? What tab was that again?
Tab 185.
Yep.
And if that exhibit can be taken down. Exhibit 4732, at the top of the second page, Ms Goldie refers to the...
Right, that's what she's referring to there.
Yes. And you saw, as I took you through...
Yes.
The plain English attachment to your email to Ms Campbell.
Yes.
In respect of the allegations raised by GetUp today from the person you say was a purported Centrelink officer. Right.
Yep.
Now, in terms of responding to Ms Goldie, you were involved in drafting the letter of response to her. Again, I'll take you to...
I may well have been. I mean, typically letters would be drafted for me from the department. I mean, you're signing hundreds of them. But in this instance, I probably would have looked quite carefully at it and maybe made some edits to it.
Okay. The two tabs I will take you to are 186 and 187. Tab exhibits 4733 and 2872 respectively. You can see there that the email from you to the Chief of Staff where you ask him to check and ask DHS to check, and then you would sign the next day. And it is a draft of a letter to Dr Goldie.
Yes.
So it may have been drafted within your office, reviewed by you and sent back to your Chief of Staff, or you may have drafted it yourself. But in any event, you were involved in that process.
I was certainly involved in the process. You're right. The chances are it actually may have been a draft from the department, which I copied and pasted to be able to edit online. I'd imagine that was how the process worked.
I want to just compare one point of the final letter.
Right, which one's the final?
The following tab, 187, Exhibit
Right.
2872. They're both on the screen side by side, but it may be easier for you to work off the bundle. You'll see in the signed response by you, the first page of which is on the right hand of the screen, and it's 7 February 2017. The third paragraph refers to the Data Matching Program Assistance and Tax Act 1990.
Yep.
And then says the online compliance system matches data in accordance with the guidelines on data matching in Australian Government Administration, brackets the voluntary data matching guidelines. Now that wasn't in the draft that you sent to Mr Aston on the 2nd of February. Do I take it from that that it was inserted by the department?
Almost certainly.
Thank you. Did you obtain any assurance from anyone in the department that in fact the system was matching data in accordance with the guideline?
No, I mean, it would be my practice that if it came up in a letter like that, you take it as this is the department advising you that this is how it is done.
I'll skip forward to stick with the topic of the data guideline. And if you could turn to tab 213, it might be in volume 3, I'm not sure. Exhibit 4754. This is an executive minute to you from the department asking that you note information signed by you 28 May 2017 and it is signed by Mr Storen from the department on the 24th of May 2017 on the second page.
Yes.
The minute informs you, as you can see there in the key points, that there is an assertion the department has previously satisfied the requirement for notifying the public of a PAYG data matching activity via public notice in the Commonwealth Gazette in 2004 and but indicates that it would be releasing that protocol in point 2 on the recommendations and a PAYG protocol 2017 on its website. You see that?
Sorry, I wasn't...
That's all right.
I wasn't following exactly where you were reading from there. Were you reading the recommendations?
Yes, in the end, you see that the recommendations...
Recommendations, a summary of that in recommendation 1. And then where were you reading from, sorry?
It was both key points .3 and recommendation 2.
Okay, sorry.
What I'm suggesting to you is that as at the time the department inserted the assertion in the letter to Ms Goldie in February 2017 that it complied with the Office of the Australian Information Commissioner's guideline on data matching, which required the publication of a particular protocol according to current measures, that in fact wasn't happening. It was only in May that the department focused on that and implemented it.
That's news to me as of today.
All right. Okay. Was it news to you that the data matching process conducted by the department for the purpose of OCI was not done under the Data Matching Act, but was rather done under a guideline?
I don't know if it had crossed my mind which act or legal authority that it was done under.
take you back to volume 1, Mr Tudge, tab 87.
Yep.
I turn to the topic of the media strategy.
Yes.
Upon your return. Exhibit 4323 CTH.3051.0015.0811. This is an email initially from your media advisor, Ms Miller, to you, and your response indicating that you would discuss it with her on 9 January 2017.
I can see that, yes.
And she sets out something of a strategy in respect of how to deal with the media going forward.
Yes.
She refers there to an op-ed for Fairfax Papers in respect of the Peter Martin article.
Mm-hmm.
The possibility of RN breakfast, which I think you referred to earlier as the most significant media interview of the day.
At that time it was, yeah.
And the prospect of tabloid stories on the success of the initiative, which used figures on legitimate debts and dollar values, numbers in the appeal, looking at Labor's record in their final year of government, other statistics, and then case studies and the benefits towards the future.
Mm-hmm.
That's my summary of it.
Yes.
Generally speaking, was that a media strategy you agreed with?
At that particular time, I mean, what you're asking me about my point, just to clarify, Mr. Gregory, when?
Was it a strategy you agreed with when you discussed that with her that day? Or sorry, on the 9th?
I can't recall discussing that with her that day. I know it says, let's discuss today. That was Monday the 9th of January and was the first day that I'd returned from leave, where my focus was very much on understanding the system, the problems with the system, and starting the fixes. That was my absolute focus. So I don't recall whether, and that went all day that first day, I do recall that. So I don't recall if we had that discussion that day or in subsequent days. I'm familiarising myself as we speak with, don't know if I need that microphone. I'm familiarising myself with this document. It might just give me a minute or two just to...
Certainly. You'll see over on the balance of pages what is attached, links to all of the media articles.
Yes.
From late December through to, I think, the date in early January.
So the question was, did I think this was a good media strategy at the time?
Or did you approve the strategy? Did you agree with it?
I don't, well, I can't recall approving or disapproving of this. I do acknowledge that we didn't do many of the things which are outlined here. And I guess if I was to reflect back at that time, as acknowledged to you, I appreciated the work that had been done and the thought put into it. My ambition at the time was to deeply understand what was going on and to ensure that any issues which I had uncovered were being fixed, rather than focus on the media strategy. So I would have thought this is a good initiative of the media team who are focused on media. But my focus, of which I spent day in, day out, was almost entirely on the system. And then having understood that, determining what media to do would then evolve in part, depending on what you actually understood. I think that was my approach, Mr. Gregory.
Can I take you to tab 98 then, Exhibit 4332? The email at the bottom is from Mr. Hannon, who you can see from his footer was the National Manager of the Customer and Media Engagement Branch.
Yep.
And it was an update to people within DHS about the media plan over the next week.
Yes.
There is a reference there to the media advisor's thinking, which is all subject to change, but
Yep.
the dot points refer to the potential Senate inquiry and how your office would work with crossbenchers to provide them with facts prior to voting on a motion to establish an inquiry.
Yes.
I take it that was something that was attempted to be done or done by your office, irrespective of the fact that the Senate voted to commence an inquiry? That is, was part of the strategy at that time to deal with criticism?
Sorry, just repeat the question. So in relation to the Senate inquiry,
Yes.
I can't remember when we knew that there was going to be an Senate inquiry, but inevitably there would be a Senate inquiry in anything which has any element of concerns or issues in relation to it. It's very standard, if there is a Senate inquiry, to want to provide the facts to members of that inquiry who are certainly part of your own political party, so that they have an understanding, and equally if there was crossbenchers who'd be open to listening to your side of the argument. So
the way it's phrased here indicates that the inquiry hadn't been established and this was an attempt to engage with crossbenchers.
yeah, sorry, you're right, yeah.
That is, if an inquiry could be avoided, that was the preferred course.
I can't recall this. My experience certainly today, and whether or not I had this knowledge then, is that if someone wants to have a Senate inquiry, they can have a Senate inquiry, and it's rare that it there's almost a convention that it doesn't. If the opposition wants a Senate inquiry, they can get one.
Right.
So I can't recall whether this, it may well have been my thinking at the time. I just can't recall.
The elements provided by Ms Golightly's group considered for the narrative, that is, the alternative view narrative identified there in the sentence commencing News Corp, is set out in the sub-dot points. You'll see the third involves correcting customer cases where you are certain of the facts, when an example is given there.
Yep.
De-identified cameos demonstrating the type of debts being recovered on behalf of taxpayers.
Mm-hmm.
And a review of cases advanced in the media which would allow highlighting of the percentage of those that had valid debts. You see those particular points?
Yes.
Do you recall approving that strategy as a way to deal with adverse media?
I can't recall it being put to me like this in the way that you've presented it, in terms of here is your strategy, sign off on that, and this is how it'll play out over the next week, month, 2 months. Some of these things we did, but this was evolving rather than a set and forget. So certainly, first, the 3 points that you raised, correcting customer cases, that was certainly done by the department, and on at least one occasion was done out of my office. The de-identified cameos, that was something that my office and I did pursue, did a significant story, which landed on the 26th of January 2017.
I think that involved quite a number of de-identified cameos being provided to the journalist.
From memory, that's there might have been. I can't recall. I won't speculate.
That's all right.
It might have been six or seven. The MO's cause is reviewing the analysis on cases featured in the media. That did relate to the de-identified cameos in that third point.
Yes.
So that, looking at the date of this, the 18th of January, there was work underway to do that, knowing that some of the cases that were in the media over the Christmas period, while purporting to be from the automated OCI system, were in fact not, and it was quite a significant proportion.
All right. I'll take you to tab 99, Exhibit 4698. It's an email from the Departmental Liaison Officer, Ms Dryden, to a number of people within Human Services, including the Deputy Secretary, Ms Golightly. This is 16 January 2017. Ms Dryden says, as discussed with Karen, the officers urgently requested the following: case studies of situations uncovered through the new system where people have owed legitimate debts, preferably large debts where there is a clear case of underreporting.
Mm-hmm.
And then the second dot point relates to the amount of debt raised in dollar terms from 2017 to 2013, how much was raised, recovered, and what improvements were made to the system. What was the significance of the period 2017 to 2013?
2007.
Sorry, 2007 to 2013.
Well, I mean, the only thing that I can think of here is obviously there was a Labor was in government during that period of time.
I see. Did this reflect the first dot point, part of a media strategy, that is to demonstrate that the system raised debts which were legitimate, preferably large ones, and that would make for a good media story?
Sorry, you're not referring now to the 2007-2013 point, back to the first point?
First point.
It was to counter there was a lot of misinformation which had been placed out of the media during the previous few weeks, and Certainly, I was keen to correct some of that misinformation, and with de-identified data to be able to point out that while someone is claiming that they were being hard done by so-called the automated debt recovery system, in fact they weren't, or in fact that it was very, very clear that they had simply underreported or not reported the jobs which they'd had during the period of time which they were receiving welfare payments.
What about the people who were absolutely right and had been hit with debt notices which were completely wrong through duplication of employer reported income, or any concern to put that out in the media?
No, I was concerned about those people and in fact took actions to ensure that everybody was contacted again for them to be reminded of their rights, to have a review, to input further information and the like. And that happened a couple of times. And there's documents, I don't know if they're in here, but certainly on the Discovery System Commissioner to that effect.
But if you spend all your time in the media demonstrating that in relation to certain cases that these people really owe a debt and really should be paying it back, aren't you creating this general perception amongst the friends, relatives, general public of people who do have a debt which they can eventually get rid of because it's not properly calculated? Aren't you creating a perception, though, that they're all the same? They all really owe these debts?
That wasn't my intent.
Well, all you had to do was explain that some of these really were wrong. And perhaps a few case studies of the ones that you really mucked up.
So, I mean, from that point in time, there was probably more of a perception out there that there was dozens and dozens and dozens of examples of people who had been unfairly treated. And in
which the department could actually corroborate.
And in some cases, that wasn't correct. And so the analysis was done of the, I think, 52 cases that were in the media over that point in time. And if I recall correctly, that analysis showed that a third of them did not involve the OCI at all. They were underneath the manual system.
Yes, which was the pilot to the OCI, so it was a bit rich to say it wasn't anything to do with the OCI, wasn't it?
I certainly would not characterise it as a pilot to the OCI. It was a development towards, the OCI built off it, and the thing that the OCI did was place an online interface on the system, but otherwise the architecture was put in place for the manual compliance, for that PAYG manual compliance system.
The manual compliance system averaged and produced inaccurate debts, just as the OCI system did. So why was there a distinction to be drawn when one was just the precursor to the other using the same methodology?
And Commissioner, the distinction was drawn not just by, it was drawn in part by me because the OCI was being implemented when I was a minister, and the PAYG manual compliance intervention had already been underway for 8 months by the time I became minister. There was 100,000 cases which were done under the PAYG manual compliance intervention system, and from the, for all intents and purposes, there was no angst in relation to it. There was no letters from ACOS. There was no advocacy from it. And it was that system which had already put in place the reversal of the onus of proof as such, requiring the, and it was that system which also said that if you don't respond, income averaging would be used. That appeared on the surface, at least when I was examining it, and in my briefings to me at the start of my term as minister, which was 8 or 9 months into the operation of that 12-month program, that it was on track. The briefings were
Yes,
track.
but we were talking about the cases provided to the media, and you said a third of them weren't OCI, but a good proportion of that third were actually earned income intervention under the manual system. And when it came to the problem of averaging, there was nothing to choose between them, is my point. So what was the point of saying, well, that wasn't OCI? How did that help?
In part because also the advocacy in relation to the system was about the OCI. So all the advocacy, all the noise, the term itself, Robodebt, was in reference to the OCI. And when you look at even the Ombudsman, when he called for did an inquiry into OCI. And so that was the distinction. That was what appeared to be causing the problems, not just in my mind, but in the mind of ACOS and in the mind of, I believe, the Ombudsman, as well as other parties. And even the opposition, Mr Wilkie's letter, it talks about the automated technological system. That was the OCI component.
All right, well, that's what you thought you were arguing back against.
That's what I was arguing back against. And that was hence differentiating from these cases which the Labor opposition had put them all out under their own admission, and under their own admission had not done checks in relation to them. And we were, in some respects, combating some of that misinformation which was out there.
The way in which this is phrased, case studies of situations uncovered through the new system where people have owed legitimate debts, inherently acknowledges that under the new system there were people who had illegitimate debts.
It certainly acknowledges, and which I acknowledged, that if a person did not have that opportunity to even know that there was a discrepancy in the data matching and have an opportunity to update their records, then it would be a debt which is highly likely to be inaccurate.
And that was the default of the system because it couldn't be done on such a scale without automation if people didn't respond.
It couldn't be done on the scale without two things. One being that the responsibility for collecting the evidence rested with the recipient rather than a Centrelink officer undertaking that work. That was the first thing, and that was a very important change which enabled a hell of a lot more, sorry, excuse my language, but a lot more interventions to be undertaken. And then the second thing, which was what was introduced with the OCI, was the mechanism of then asking the recipient that having got the evidence to upload their evidence online rather than the compliance officer entering that information into the database.
And where that didn't happen, generating a debt by applying averaged income.
Yes, which my understanding then and to this day, I still believe the case, is that this occurred going back as far as 1990 and most likely going back as far as 1981.
The first significant change, that is the shift in the onus,
Yes.
meant that it would not be accurate to say there has been no change to the way the debt raising process is done under the Robodebt scheme or its precursor.
That is certainly a change. The essential architecture, which I articulate in my statement, was effectively the same. So there was evolutions within the essential architecture, and I outlined 5 elements in my statement, as you'd be aware. That was certainly a change. My understanding, going back to the information that was presented to me in early January, was that typically the compliance officer under certainly the old scheme would call the recipient initially, ask the recipient if they had information, get consent from the recipient to call employers or to call the banks to get statements and enter that information themselves. But if they did not have that information, as the process map, which we had up on the screen said earlier, then income averaging would apply.
Another aspect of the strategy to combat what you've described as misinformation, and it's at tab 105, is the request from your office for the top 20 potential overpayments identified through the OCI scheme.
Yes.
You'll recall that?
Yes.
And that made for good rebuttal to the suggestion that the scheme wasn't picking up people who didn't, was picking up people who didn't owe money.
In part, I think that was the case.
Can I take you to tab 120, exhibit 4709.
Yes.
You can see there that your DLO attributes to you a request that the attached cameos be updated with new information and new cases added.
Yes.
And that relates, as the attachment indicates, or the title of the attachment indicates, details of customers that have appeared in the media.
I don't have the attachment.
It'll be behind the next tab, I think. 123, tab 123.
Mm-hmm.
But again, as part of the way in which your office responded to adverse media under your direction, there was the direction to the department to collate the summaries of persons who had appeared in the media and for information about them to be put together in a document which was current at any given point in time and could be relied on as part of the strategy.
This was, again, I mean, if I look at the second case there, the media, Albanese Media Conference, this is not an online compliance intervention case. It was part of an income tax return review.
Let me ask it a different way. Did you direct through your DLO the department to collate details of everyone who appeared in the media complaining about inaccurate or unfair processes related to the OCI scheme?
No.
Do you say they did that off their own bat?
I suppose two things that I'd say in response to that in terms of what I did do. One, that I was keen for an analysis of what I believe were 52 cases that were placed in the media between, let's say, late December and mid-January, which is a quiet media time. And I wanted that analysis done for the purpose that we were discussing before. The second thing was that if there was a case in the media that I always wanted to know where there was substantial cases in the media that appeared, that on the surface appeared that someone was very harshly done by. I wanted to understand that. And more than understand that, I in fact instructed my team and the department that if there was concerns, and they were legitimate concerns, that a member of the department was to call that person, talk it through and talk through what their rights and responsibilities were and how they could address any particular concern.
Mr. Tudge, irrespective of an attempt to correct genuine grievances, you wanted to assure yourself that you were able to demonstrate that the system was working as designed to the public.
My sense at the time, and I think I communicated this with Minister Porter in a subsequent Cabinet submission later in 2017, was that while there were problems in the system, there was an orchestrated campaign, if you like, against this. And this was in part presenting information to balance out that and correcting the record and to present the case of what we were doing.
And that culminated with the article published by The Australian on the 26th of January 2017, in which the balance, as you described it, involved.
Yes.
You've been closely involved in analysing all of the cases, reviewing what was provided to the journalist over the course of the 23rd of January with the various points that you wanted to be attributed to you about the validity of the scheme.
I hadn't been closely involved in every case, but certainly I'd asked the department, and I imagine my office would have analysed every case. Certainly the cameos which were put together, the de-identified ones, I'd be wanting to make sure that they absolutely were very, very clear.
If you go to tab 131, Exhibit 4349, 4350. Yes, sorry, just 4350.
Sorry, what was the second tab? The first tab was 131.
Yeah, just 131 at this point. Thank you, Mr. Tudge.
Okay, mine's just... Yep, that's all I have.
An email from you to Ms Miller and Mr Aston and Mr Wood, 23 January, about 9 in the morning. The attachment is collated information, and you indicate to those three recipients you've edited the document. It's still not ready. The data is not clear enough. It may be able to be fixed this morning. Please look carefully at this, particularly the 2/3 of the 50 cases owe money. Now, can I take you then to the attachment, which is behind tab 132, Exhibit 4351. And this was the material being drafted for the journalist for the publication, which appeared on the 26th.
Yes.
The summary of the story is set out there. You'll see dot point says 2/3 of the people who've been featured in the media are being victims have actually been overpaid and legitimately owe money back to the government.
Yes.
And if you go to the page ending .5880, the third page of the document, you'll see an elaboration of point 2, which has that as the title. And highlighting which reflects your edits, correct?
Sorry, what was the actual question then?
The highlighting reflects your edits.
Reflects my evidence.
Edits, ED.
Edits.
Yes, yes. What you said in your email, which attached it, was I've edited the document.
Oh, it's that, I don't know.
All right?
Is that, if that was the case, then I'd take your word for it. But
it was tab 131, you'll see your email.
So these highlights were on the
attachment.
On the attachment
to your email.
To that email,
yes,
which I'd sent to those 3 members of my staff.
Yes.
With these highlighted.
Yes. You can see one of the highlights there is these lines are not robust enough, which appears to relate directly to what you said in your email when you said, please look carefully at this, particularly at the 2/3 of the 50 cases owed money. Yes.
Yes.
Now, can I just pause there? This suggests, in this form, from this analysis, where it's being developed for an article in the Australian, that you were aware that the analysis revealed that 1/3 of people had not been overpaid.
Right.
It's a significant
No, I don't think
percentage,
that,
isn't
sorry, that does not follow from that statement. The other third, it's unclear. So 2/3, if my recollection serves me correctly, Mr. Gregory, there was 2/3 of cases where on the evidence that we had, it was very clear that money was owed. And typically, they would be because there was cases where, for example, during the period of time the person was claiming welfare payments, they had not, for example, declared the second job, which was clearly across the same period of time that they were receiving welfare payments. In some of the other cases, on the high level data that we had, it was unclear and you couldn't make that definitive conclusion. I think that's my recollection of this, Mr. Gregory. So the third of cases which you referred to, there may have been some cases where there was inaccuracies, and I accepted that earlier today. But I'm not claiming here that 1/3 of all of those cases were inaccurate.
Can I take you to tab 133, exhibit 4352? The point, Mr. Tudge, is that you remained closely involved in the drafting of the material that went to the Australian on 26 January 2017.
The drafting of the material, I was closely involved in assuring myself of the accuracy of what was going out.
Can I take you to tab 139, exhibit 4360, later the same day? You say to your media advisor, I've edited this down further.
Yep.
Need to add the Triple J story, need to get written confirmation that we can release a particular person's information. It suggests you were involved in the editing of the material that went to the Australian.
I was certainly, I wasn't trying to deny that I wasn't involved in the preparation of the materials for the Australian. I was very much assuring myself that the information that we were putting out was accurate and defendable to the best of my ability. That's what I was trying to do.
Can I take you to tab 145, exhibit 4363? And the next day, 24 January 2017,
Yep.
the document is again forwarded to you.
Yes.
And your advice on whether further edits are required was sought.
Yep.
It's not merely a matter of ensuring accuracy, is it? You are checking the language of the document for what would be the first major rebuttal of what you described as media misinformation in January.
Was I checking the language of the press release? Yes, at that stage. It would have evolved from doing the analysis and working out what we could very clearly state from an analytical perspective ensuring the department had supported that analytical perspective, in fact did the analysis. And then second, it would have evolved into, let's put together a press release in relation to this. And I would have had a view as to that press release and certainly would have wanted to clear the quotes which were attributable to me. And that would be involved. There's quite a lot of work for this particular story to do that analysis, obviously, and to be assured of the robustness of that analysis, which is what my focus was on initially. And I can imagine at this stage, as I said, this would be when quotes were inserted. I would want to be assured that the quotes were ones which I was comfortable with, as well as the overall tone and language.
Can I take you to tab 152 to complete the loop, exhibit 4369?
Yes. Yep.
You are updated with the information which was sent to the journalist and informed that a copy had been sent to Minister Porter's office, and it contained the material which was used by the journalists in the publication of the story, or in the story published the following day.
Yep.
And if you go to tab 154, exhibit 4371.
Yes.
You'll see in the copy of the article, debt scare backfires on Labor, which was the article that appeared that you referred to earlier from your recollection.
Yes, that's right. And it's also when it's where that the opposition spokesperson suggested that they were the ones that were collating this and putting the stories out.
Yes. You'll see over the page, dot 6574, there's the box on the side, welfare theory and facts. There are de-identified welfare recipients, A through D, which contain a short summary of the facts as they were provided to the journalist.
Yep.
It wasn't the case, though, that information always came from your office, which involved de-identified recipients. There was an occasion when a person who had appeared in the media and criticised Centrelink during this period was met with a response which plainly identified who that person was, details of their personal information.
And that case had nothing to do with the OCI or the PAYG manual compliance system or the system before that.
But it did have a lot to do with the media strategy whereby rebuttal through the media confronting what was said to be inaccuracies about adverse media criticism would be met
well, I think...
with case studies.
Sorry to interrupt. I can't recall the date of that particular one. It's written in my statement. I don't know if the name is redacted.
22nd of February. I think the name is redacted, yes.
My statement. 22nd of February, so this is afterwards. And it was a particular case. As I said, it was not a case which at all related to any of the schemes which became defined as Robodebt.
But what difference did that make? Why did you consider it was appropriate to have that person's details released in the media?
The situation in that regard, and I assume this was still within the scope of the Royal Commission despite it being outside of the programs defined as Robodebt.
Well, we're talking about possibly, on some evidence we've heard, a strategy to intimidate people who might have complained about Robodebt.
Right, okay. Well, that's I disagree with that, Commissioner. But I've addressed this in my statement, as you know, Mr. Gregory, so I'm happy to continue. This was a case where it was not just a story, but a 1,200-word piece, which was the prominent opinion piece in each of the Age, Sydney Morning Herald and Canberra Times. So a big opinion piece, most opinion pieces are 800 words, and the feature opinion piece in each of those newspapers. I appreciate the Commissioner at some stage, knowing her evidence, had said that it was in a blog. It wasn't in a blog, it was very much a very prominent piece. And in that piece, if my memory serves me correctly, it said that she had been terrorised by Centrelink, is the word that she used, for a debt that she did not owe. My concern was that would give a false impression to the community at large, and indeed install some concerns amongst the community at large that Centrelink was being overly aggressive towards people who, to everybody basically, who was on a Centrelink payment. And I don't believe that was the case. And so, having sought advice...
Do you mean legal advice?
Yes.
Right.
So I sought advice from the department, which was in the form of legal advice, as to whether or not the record could be corrected on here. I can't recall whether that was my initiative or whether that was someone else's suggestions, and either way it came from my office.
With your approval?
With the Chief Legal Counsel's approval to release, I think, 3 lines, 4 at most.
There's a distinction, Mr. Tudge, between legal advice, which says it's permissible, which is all Ms. Mussolino could do, and the approval to release the information publicly, which was your decision.
That was my decision. In hindsight, and I've said this many times, that it should have come more from the department to correct the record rather than from my office. But it did come from my office, and I'm confident, having gone through the process, that it was lawfully done, and it was done to correct the record of that one particular instance, which was by far and away the most prominent case that had been released, not by anybody else other than herself, in terms of writing a 1,200-word opinion piece.
It made very clear that if somebody wanted to criticise Centrelink in public, they were taking a risk.
That was certainly not my intent, Commissioner, in doing this. And I appreciate that others may have put that, but it absolutely was not my intent to do that. And in fact, I believe that in some of my transcripts you'll find that I said on radio interviews that fair criticism of us, legitimate criticism, is that's the way our democracy works. In this instance, I think it was illegitimate criticism, which was prominently displayed by the then Fairfax media, without any checking on the information which was presented in that piece.
As you can see, government going after an individual is not an encouraging look.
Sorry, encouraging for?
For anybody who might want to make fair or unfair criticism.
I can only say, Commissioner, that was certainly not my intent.
All right.
Did you consider it as a possibility and take the risk?
My consideration at the time, Mr. Gregory, was that leaving this article to stand, being so prominent in the Fairfax papers, could actually have the reverse effect that would make some people concerned about the operation of Centrelink.
stands to reason then that the converse effect would be communicated by the release of personal information. People would see that and go, okay, I now know what will happen if I publicly criticise the department.
Again, my intent was not to have that effect. My intent was as I explained, and my concerns for doing so were as I explained.
Irrespective of your intent, did you appreciate that potential consequence? That you weren't just correcting the individual circumstance, you were sending a broader message, or it might be interpreted in a broader way.
Well, as I said, in hindsight, I wish the information, had it been released, would have been released from the department, because it would have downplayed the information. The information would have been the same.
You had a government department going after someone. Do you think that would have been an advance on your office doing it?
It elevated when a minister's office is involved in doing it, it elevated the story associated with it.
You might be right about
and then that was amplified, of course, as well by the opposition at the time, who decided to do a referral.
Yeah, but that's a side issue, isn't it? The effect of what happened has nothing to do with the fact that you were then referred to the AFP. That's another set of facts, isn't it?
I think it gave it more prominence, and is probably one of the reasons why we're discussing it today, is because it gave it prominence and therefore was in the media for a couple of months while the AFP did an investigation and subsequently found that it was a lawful release.
So it seemed to have been a terrible idea from start to finish.
As I said, in hindsight, I would have preferred that the record was corrected in a different way.
Staying in touch with the media as you did, you were aware of the articles which followed the release of that information, which clearly conveyed the chilling effect that would have upon people who felt that they had been unfairly treated by the department.
I can't, when you say, am I aware of those articles? I'm not aware of those articles. I may well have come across them at the time, but I can't recall them now. I mean, that case sticks in my mind because of the prominence of the story, the release of the information, the fact that there was a referral to the AFP, obviously, which was obviously squashed. The Privacy Commissioner got involved and said that there was nothing further to look at.
Mr.
That's why.
Are you saying?
That's why it sticks in my mind.
Are you saying you don't recall any criticism of your office about the release of personal information because it would have that chilling effect?
I don't recall it precisely in the manner which you describe. I recall some criticism of it. And in some respects, my recollection, going back 5 years of this, was the recollection of, yes, there was a response, and it was almost instantaneous response from the opposition. And that's the main issue that I recall, Mr. Gregory. It's not to say that I didn't see articles at the time. I may well have seen articles at the time, and you may well be able to present it in these documents that there were such articles. I'm just saying that my recollection is that I recall some criticism.
Would you agree that the release of that person's personal information was an indicator of the approach that you took to defence of the department generally?
An indicator? No.
I turn to the question of suicides related to the scheme. You'll recall that in February 2017, an article was published in the Saturday paper related to Reece Corso's suicide following an interview with his mother.
What tab is this, sorry?
Tab 170, Exhibit 4407. Speaking generally and not by reference specifically to this case, you will recall that on occasions it was brought to your attention that persons had committed suicide at some point after receiving letters generated by the scheme.
I do recall, I don't recall the details of this case, but I do recall that this person tragically did commit suicide, and I do recall that this person was subject to a welfare compliance check, and it was not related to the OCI.
It was the PAYG Manual Compliance Intervention Program.
Right.
Correct?
I'm not sure. I know it was not the OCI, and it was referred to, I think, even my recollection from reading some of the documents, as the manual system.
Yes, which involved averaging.
Well, as my evidence suggests, I don't know which system it was under, but all of the systems involved averaging.
The way in which your media advisor draws this to the attention of you, your Chief of Staff and your policy advisor,
Yes.
is in, would you agree, particularly insensitive language?
So which document are you looking at?
The one on the screen.
I've got the wrong document here. What number was that again? I
Tab
thought it was 170.
Tab 170.
Okay, that's not 170 under mine. Oh, sorry, I've got the wrong tab.
Come over one, I think, maybe.
Okay. No, I've got it actually. Thank you, Commissioner. I can't.
I'm sorry, I'm going to stop you there. I'd completely forgotten that the transcribers need a break, and I had lost track of the time, to be perfectly honest. So we'll just stop for 5 minutes.
All rise. The Commission stands adjourned for a short break. Royal Commission is now in session. Please be seated.
Yes, Mr. Gregory.
Thank you, Commissioner. Mr Tudge, I was turning to the suicide of Mr Corso by reference to tab 170, Exhibit 4407.
Yes.
And your media advisor drew your attention, your Chief of Staff's attention and your advisor's attention to an article published in the Saturday paper on Saturday 18 February 2017 about that. The points which arise from the email are firstly, the timing of this was a few days earlier than your decision to release personal details of the person we've just discussed, which occurred 4 days later on the 22nd of February 2017.
Yes.
Secondly, that the language used by the media advisor was particularly insensitive. Would you agree with that?
Yes, I would.
And did that insensitivity reflect the mindset or culture within your office that really this system was catching people who owed debts and people who were getting caught were whingers?
No, I don't accept that that was the culture that was put in my office at all. I mean, this was a tragic case. So I broadly remember this case.
Nonetheless,
as any suicide is.
Nonetheless, it seems that your media advisor was comfortable expressing herself in this way directly to you.
The email is there.
All right. Can I take you to the next tab, 171? Exhibit 4408. The first email is from Ms Miller to you. At the bottom of the page, the full case study from the department, a plain English version below, your response, which identifies that the information from the department doesn't clearly say why the debt was raised, that is, the period of time, the reporting, and the earnings.
Yep.
You see? And then
yes,
Mr Aston replied to you
yep.
with...
Advise against it. Mm.
Yes.
And I think that by the looks of it, I was reading this without that understanding.
Yes, the passage...
That this person had sadly died, so...
the passage I'm referring to is not the called out one on the page, it's at the top of the page, yes. And your Chief of Staff strongly advised you,
Yes.
that it might be a bad look to provide some details about this person in the media in response.
Yes.
The response from your office is in the following tab, 172, Exhibit 4721. See at the bottom of the page, a specific request is attributed to you.
Yes.
Particularly that an investigation is opened into Mr Corso's circumstances. You wanted a brief, and the intent was to be able to update the letter to include a similar line to Searle's to another letter stating that he had investigated the matter and was confident the department had done everything correctly, etc. You can see that?
Yes.
And that goes through a series of hands then towards the top of the page. And you'll see...
I do, from memory, I do recall asking there be an investigation into Mr. Corso, but...
The information developed after your request was the briefing team had created a minister's brief ending in 300, which has the correspondence brief and a draft response included.
What tab is that, sorry?
Tab 174, Exhibit 4722. Paragraph 1 under the heading Key Points identifies your request to undertake a review of his case. It was done. And paragraph 4 confirms what was hoped to be the response, that all interactions were appropriate and undertaken in the parameters of departmental processes.
You put something to me there that was what I hoped the response.
The letter which you signed is at the back of tab 174. It's addressed to Ms. Jennifer Miller, dated by you 2 May 2007.
Yes.
The page, I think, is _0008. And you can see in paragraphs 3 and 4 that you were able to write to her saying, sorry, that the investigation enabled you to say what is said in paragraphs 3 and 4 there. That you asked your department to undertake a thorough review into its interactions with your son, and the review was conducted by very experienced officers who were in no way involved in the handling of Reese's case. And while the review identified some minor errors of an administrative nature, it concluded that both the department and its agents' interactions with your son were handled appropriately, professionally and sensitively. You see that?
Yes.
Did you ask for an investigation into whether the role of averaging in the letters sent to Mr. Calzo led to inaccuracy?
I don't recall the terms of reference for this investigation.
Surely it was of some concern to you that the media article in the Saturday paper related the debt letters as a factor, not necessarily a decisive or directly causal factor, but related the debt letters as a factor relevant to the suicide.
It concerned me certainly that was put, absolutely.
Because there may have been other cases, but at least in terms of the documents, this is the first point in time when the potential adverse consequences have gone beyond a matter of mere finance.
So I was concerned, and as was typical of my approach then, was to try to understand quickly what had occurred that had led to this. I think in a previous tab it actually goes through and says this wasn't an OCI as such, that this person did have a vulnerability indicator on, which typically meant, well, certainly under the OCI, they would not be subject to any income compliance audit. It gave the indication, I have to look back at this, that it was done by professional officers. So I did want to absolutely, to answer your question directly, understand what had occurred when an allegation or a position is put like that in a newspaper.
But the extent of the investigation did not address the two valid criticisms that you accepted earlier, that averaging created the potential for inaccurate debts and that there was a reverse onus in this system. It dealt only with whether officers interacted with him in a polite or respectful way, implementing that system.
And I don't believe that in terms of the first point, the reverse onus, I'd believe that a compliance officer was involved in assisting the individual, is the way that I read one of the documents here.
But you understood under the PAYG Manual Compliance Intervention Program.
Sorry, say that again.
You understood under the PAYG Manual Compliance Intervention Program that averaging was used.
Yes.
And people were directed to get pay slips for the relevant period of time, in the absence of which debts were calculated.
I don't know, and I can't recall being provided with the information as to which system that he was reviewed under, whether it was indeed under the old system, pre the PAYG compliance intervention, or under the PAYG compliance intervention program, but he certainly wasn't reviewed under the OCI. And I'm just looking at tab 70, where it does indicate a vulnerability indicator, and I certainly know that under the OCI, if you had a vulnerability indicator, you weren't subject to review. And I can only imagine that under the PAYG system, the same would have been the case, I'd assume, but I don't know.
Well, I might just take you to the executive minute behind tab 174,
Yep.
exhibit 4722. Attachment A ending .0591. You'll see that review 1 is addressed on that page.
Sorry, 174, tab 174.
Tab 174.
Yep, which is the letter that you were referring to previously.
Yes, and you'll see that attached to the executive minute is attachment A, 3 pages in.
Yes.
Review 1, that is, the review initiating the first debt,
Yep.
6 May 2016. That's the period covered by the PAYG Manual Compliance Intervention Program. And you'll see review 2 on the next page was selected for a further review on the 31st of August 2016. Plainly, under the PAYG review, there was a compliance officer involved, but applying the business rules we identified earlier in your evidence.
Yes.
which included averaging and the reverse onus. And in review 2, that was under the OCI period, although, as is identified at paragraph 13,
Yes.
there was a compliance officer involved as well, but plainly the same rules, averaging and the reverse onus. Right.
From reading this, it does become I would gather from reading this that it was done under the POIG compliance intervention.
Yes. Mr. Tudge, the suggestion of a suicide related with or associated with debt letters generated by this strengthening the integrity of welfare payments measure must have caused you to reflect on whether the inaccuracies that was the potential for inaccuracies built into the system and the reverse onus was really worth pausing the system for.
Well, we did pause the system.
Did you do it because of this?
Again, the date was, it was already paused by then. This is dated, doesn't have the date on the front page of this.
The article was published 18 February.
So the article was published 18 February, it's already paused by then.
Right. Yeah. So you didn't pause the system because there was a potential suicide associated with it.
Paused.
But surely when you found this out, you must have thought to yourself, the questions of accuracy and the reversal of onus are matters of real significance to the people who are affected by this scheme.
I thought to myself that to do welfare compliance, it has to be done sensitively and well, and there has to be absolute reasonable opportunities for everybody.
Before we get to reasonable opportunities, there has to be a reasonable basis to raise a debt.
And for any, I know from experience of even people close to me who have committed suicide that you can't always know what causes somebody to do that. And I was concerned about this, and hence I asked for a review to understand what responsibility there was on behalf of the department and their interaction with him that may have exacerbated any situation.
Can I add another angle to the one that Mr. Gregory's raised? He's raised accuracy and the reversal of onus. There's also the going back years. This man in May 2016 is told he has debts from the 2010-11 year, 2011-12 year and 2013-14 year, and he's supposed to contend with that, a vulnerable man who's known to be anxious and depressed. To add to that, he then, after having to deal with all of that, in August is told that there's another debt from the 2012-13 year. So he's being asked to contend with debts dating back years, and you're doing this to a large population of people, many of whom, whether they've got vulnerability indicators or not, will be vulnerable. Is that not a concern?
It was a concern, it was certainly a concern to me, and going back to the broader point, Commissioner, my concern particularly within my authority as Human Services Minister was to ensure that the system could be as easily understood, as reasonable as possible, where a person could easily find the information through, for example, bank statements, where people were, if they had any vulnerability indicator at all or any sense, were excluded, where people could speak to a customer service officer immediately, within seconds, where that was understood. That was my authority to fix and address the problems which I saw to make it fair and reasonable from that implementation perspective.
You didn't think it necessary to raise any question of whether, for the reasons Mr Gregory's identified, the accuracy issue, the putting the onus on people who may not be well equipped to deal with the system, and the going back years, it might be better to reconsider whether this program should continue?
And at the time, Commissioner, operating within my authority to implement the Cabinet decision. So the Cabinet decision, which I didn't have the authority to overturn, had made those decisions to review certain years, to place greater burden on the recipients to find the data, and also that income averaging would be used as a last resort when people did not respond. They were the Cabinet decisions, which I didn't have the authority to overturn. My authority was to fix the implementation and the operations of the system, which was my very sharp focus. And I believe, Commissioner, that the things which I did put in place, including effectively pausing things until they were better in place, having that customer service officer there, having the 1-800 number available within seconds, being able to use bank statements as evidence, which are more readily available, were effectively more reasonable and for individuals to be able to engage with. Certainly ensuring that everybody was called before and notified to ensure that they actually were aware of their rights and responsibilities. All of those steps which I put in place were squarely under my authority, which I put in place.
But you were the minister on the ground and you could see what was going on. Were you not able to report back to your colleagues that there were these problems arising and that this scheme was harming people?
So, I mean, both my immediate report, Christian Porter, as well as the Prime Minister, were aware of the issues associated with what came to be defined as Robodebt. And I had, for example, several briefings with Prime Minister Turnbull, conversations, briefings, formal letters sent to him. His office was well aware, and there was no indication to overturn the decisions of the Cabinet in 2015.
Well, a cynic might think that's because there was too much money riding on it. Would that be fair?
I didn't have the authority to make that decision, to overturn those decisions.
All right,
and I don't know what the rationale was for those who had authority to do so.
And you regard them as being the Prime Minister and the Minister for Social Services?
So to overturn a Cabinet decision, so that the Cabinet established these schemes effectively in the architecture of these schemes, and then the responsibility of Human Services is to implement those Cabinet decisions. So my authority was to do that.
To go back to Cabinet with, I suppose it would be a new policy proposal, I don't know.
Yes.
Saying this thing has turned out very badly in real time for real people, it should not continue. You can't do that? I would just say, Commissioner, that there was ongoing engagements with the Prime Minister's office, with the Prime Minister himself, in terms of understanding what was going on. And there was no indication of a desire to overturn that Cabinet decision. There was no request
sort of put to say, you better bring this back. There was a request to update the Prime Minister, which I think occurred from memory in writing in early 2017, from Minister Porter and myself. And that equally provided further opportunities. And equally, ACOS was engaging directly with the Prime Minister as well.
Mr Gregory?
The letter that you and Mr Porter co-signed to the Prime Minister is behind tab 259, exhibit 3671. That's the document you referred to in your answer to the Commissioner?
Yes.
The letter indicates it's an update to the Prime Minister about the progress of OCI, to set out action taken to address issues raised in the media and to discuss how OCI will be managed going forward. You start by identifying the source of the measure and its value to the budget. And then you go to address the significant investment in countering misinformation about OCI. Do you see that?
Yes.
Would you agree with me that as the letter continues, you don't identify that in fact there are valid criticisms of the scheme giving rise to inaccuracies in the calculation of debts?
Can you give me a moment to
Of course.
read through it? Sorry, Mr Gregory, what was the question?
Nowhere in the letter do you identify that there were valid criticisms of the scheme in respect of the potential for inaccuracies built in as a result of averaging.
No, but it was pretty well understood, even by virtue of the reference to the refinements made to the OCI, that there were substantial changes made to it to improve the system.
It was implied, do you say?
Pardon me?
It was implied.
It was implied, and it's not like this came out of the blue to the Prime Minister, the Prime Minister's office, or the Department of Prime Minister and Cabinet.
But what was the improvement about averaging? You'd paused for the time being, but when you went back, you kept on averaging, didn't you?
No, that is the case, Commissioner. The pause occurred while the improvements to the system were made, some of which are articulated in this letter.
Just while I've got your attention, can I just make a point to you about those case studies sent to the Australian? I had a look at them. The information to the Australian is that there are so many debts as a result of these case studies, some given number, I haven't got it to hand at the moment. But those cases were all still the subject of debate with the department. You know, the recipients were busy arguing about things with the department through January, it seems. Most of them are current with actions occurring during the month of January. So they're by no means complete by the time you're giving them to the journalist who reports on the 25th of January. It's not as if anybody has said, yes, well, some have entered into debt repayments, but very few. And even of those, some are cases where there were thousands of dollars raised in debt and then you're back to a couple of hundred. You can see why somebody might enter a debt repayment. But the thing is, they're current cases and they're being presented as, oh, here we are, here's the proof. Is that a fair comment or not?
I'd have to go back and check those cases, how many were still open and current, as you point out.
There was a point made that a certain number had applied for reassessment.
Right.
But many of them were still in flux, as far as one can see from the case studies.
I can't recall that point, and I'm not disagreeing with you.
Okay, well, I'm just raising it. If at any subsequent stage you want to say anything different, you've got the opportunity.
I suppose the point I'd say, though, in relation to that, Commissioner, if I may now, if that's okay.
Sorry?
If I may make a point now,
sure.
Was that the cases that we're particularly looking at were ones which, certainly on the face of it, was very, very clear that a debt was owed because, for example, the evidence would show that a person was in receipt of welfare payments for, say, the duration of the year, and that had completely failed to declare a job which that person had, which the ATO records showed. And there were cases like that where they were the ones which it was very clear that debts had not been declared.
I'll look more closely. That didn't strike me, I must say, about them. It seemed more that in just about all of them, the debt raised was not the debt that the department arrived at. In the first instance, there was a reduction. But the other thing that struck me was their currency. But I'll look to the point you make, which is that they involved people who had not declared an employer.
Or that would, and this is why we went backwards and forwards a bit, which Mr Gregory was saying for me to examine this. And I was being rigorous in terms of saying, are we 100% sure that those cases that we're saying that did owe money, it was so clear on the evidence that was presented that there was no way that the mathematics almost could be done where the person didn't owe money, that there wasn't an overpayment. That was what I was looking for. It may be, as you say, Commissioner, that it was downgraded from $1,000 to $500, but it was clear that there was an overpayment.
All right, I'll have a further look. Thank you.
Mr Tudge, while you have your letter to the Prime Minister there, can I take you to the third page, .0947? You'll see the final dot point. We will pursue ongoing improvement of our processes. And there's the reference to the engagement of PricewaterhouseCoopers. I have three questions. Firstly, was the engagement of PricewaterhouseCoopers part of a media strategy to enable you to say that an independent consultant had been engaged to look at the flaws in the system and would provide information back to your office?
No. And the evidence of that, Mr Gregory, is that that decision was not made by me, by my office. It was made independently by Catherine Campbell.
Now, did you encourage her to engage them?
Not to my recollection. I think from my memory is that she informed me one day that she had decided to engage PricewaterhouseCoopers. Bearing in mind that this was at a stage as well where a lot of the media heat had come out. The media heat was very much in January and parts of February, and from memory that the PwC was engaged in April, possibly, March. So it was part of a genuine effort to say, let's put another ruler over this to see if there's further improvements we can be made.
In terms of the work product of PricewaterhouseCoopers,
Yep.
which you say you were pursuing ongoing improvement in respect of the process, do you recall being shown a series of PowerPoint slides in respect of a preliminary analysis they conducted?
Yes, I believe that I was. I can't recall the details of those slides, but I believe that I was.
And do you recall asking for production of their report at the end of their review?
I may well have done, but I can't recall that.
Do you recall seeing a report at any point?
I don't recall it, but the likelihood is that I would have asked for a copy of the report and to flick through it.
So there's no uncertainty about it. I suggest that PricewaterhouseCoopers were engaged in February 2017.
Right. What was the date that they were engaged?
2nd of
2nd of February.
February, yes.
I mean, my point stands in terms of that wasn't my. I have strong recollection that it was not my recommendation or initiative, but rather that it was initiative of the Secretary to engage PricewaterhouseCoopers to do another independent look at the operation of the OCI.
You'll recall that the Ombudsman produced drafts of a report and then a final report.
Yes.
In April 2017. Do you recall that you considered that report to be a good line of defence in respect of criticisms about the lawfulness and accuracy of the scheme?
I don't recall the way that you characterise the Ombudsman's report. The Ombudsman is a very serious independent authority who independently, at the beginning of January, decided to undertake an investigation into the online compliance initiative. And I was obviously aware that it was being undertaken, and I was looking forward, concerned, anxious about what the Ombudsman might say. And then when the Ombudsman's report did land, I obviously read through it carefully. There were recommendations in there, and all of those recommendations were adopted, which was a position which was outlined in the report. And I also worked very closely with Catherine Campbell to ensure that every single one was implemented fully.
Can I take you to tab 246 then? Exhibit 4400. See your email to your advisors and Chief of Staff. The attachment is the Ombudsman press release. Please use this as the basis of the press release. Please check this closely and offer any suggestions for improvement, but I think it's quite powerful. I think the heading should be flat and let the release and report speak for itself. And if you go to the attachment,
I don't have the attachment.
behind tab 247, exhibit 4401.
Yep.
You can see that
Yes.
what is emphasised in the draft press release are the Ombudsman's findings about reasonableness,
Yep.
the criticism in respect of the reversal of onus being answered by the finding that it's entirely reasonable and appropriate for DHS to ask customers to explain discrepancies?
Yes.
A finding in respect of the accuracy of the system, and support for your position that nothing had changed in respect of data matching for many years. Again, did you consider that the release of that report provided a good line of defence to criticisms in respect of the lawfulness and accuracy of the scheme?
Certainly that there were strong messages in the Ombudsman's report, who independently examined the OCI, and his conclusions were in line with many of the government's conclusions. And so, yes, to rely upon an independent authority to say that it was reasonable to ask recipients to explain was, of course, something that I would do when I was pressed on it. So it's not just me sort of saying it's reasonable, but the Ombudsman himself has looked at it and said that it's a reasonable thing to do.
It also does quote you as saying that it showed that the system could accurately calculate debts owing. There's a bit of a typo there, but that's what it seems to be saying. That didn't cause you any qualms?
That's what the Ombudsman said in his report.
But you knew better, surely.
What the Ombudsman said, if I recall correctly, Commissioner, was that it accurately calculated when a person was able to engage and input their information. So it was the system in its entirety that it was reasonable to ask them to explain, and it was reasonable to ask them for information. If they provided that information, then the system produced an accurate result.
Right. So that's implicit in your statement.
That's what my understanding was of his statement. And he goes on, from memory in his report, to discuss income averaging as well, and refers from memory, I'd have to check this, that it goes all the way back to 1981.
I'll turn to a different...
Sorry if I may, just with one final point, Commissioner. And I recall specifically, and more, perhaps more so in hindsight now, but there was the Ombudsman and nor the Auditor General, neither of them made comments in relation to the lawfulness of the scheme. In fact, there was an attachment from the Secretary of the Department of Social Services that said that it was operating lawfully, nor in relation to income averaging, saying that it should stop, nor in relation to closing down the scheme altogether. I mean, that was both of those two independent reports, if my recollection serves me correctly.
Look, just while I think of it, before you mentioned averaging as a last resort, there's been a lot of discussion of that expression.
Yes.
But most of it would take it as meaning after you'd exhausted every possible means of obtaining information, including from employers. How were you taking it?
I appreciate that that's a term which has come up throughout the Royal Commission. I'm not sure if I was aware of that term when I was Minister for Human Services.
See, that was the critical qualification to averaging in the past.
Yes, I'm aware of that now from reading some of the evidence in relation to this Royal Commission. I don't think I was aware at the time, and moreover, in part for some of the reasons I've articulated, but also I was focused, without wanting to repeat myself, on what was within my authority rather than trying to overturn a cabinet authority.
All right. And look, can I just get clear your evidence about that? Did you ever actually say to Mr Porter or the Prime Minister, who would have been Mr Turnbull, that consideration should be given to stopping this program?
No.
Mr Tudge, I'll take you to the Ombudsman's report so that your answer can be given. Context, tab 201. It's at the end of folder 2 in my bundle, but it may be the start of volume 3 in yours, I'm not sure. The exhibit number is
4744. And the particular page is .7539_0044. If you have a different copy of it, Mr. Tudge, it's page 42 of 110.
Page 42.
Yes.
Use of averaged ATO income data.
Yes.
Yeah.
This is the passage to which you just referred in your answer to.
That's my recollection.
Yes. You'll see paragraph 2.3.1 on page .7539.
Sorry, Seth, I wasn't focused then. What did you say?
You see paragraph 2.3.1,
Yes.
confirmation of what you already knew about a fortnightly income test, and that
Yes.
and that ATO data normally provides an aggregate annual employment income figure and does not provide the detail required to accurately assess fortnightly social security entitlements. You see that?
Yep.
And in paragraph 2.3.2, which I think was the passage you were emphasising,
Yes.
Commissioner, the reference that DHS always had a process for averaging ATO data to calculate debts, and it continues. The quote is, if every possible means of obtaining the actual income information has been attempted, it is possible to use any evidence available to raise a debt, including an annual figure. Pause there. The phrase used by the Commissioner in the question was as a last resort, but you would agree that that concept of as a last resort, as it's so resonant in this Commission, is really a reflection of the circumstance in which every possible means of obtaining the actual income information has been attempted.
It looks from reading this here that that's what, that's what the Ombudsman says here.
Yes.
And I note in that footnote that it does say that it's been going back to the 1980s, both in manual and OCI systems.
Sorry, which footnote are you referring to?
Footnote 101, which was connected to that first sentence.
Thank you. You also understood, though, that in the old scheme, as it was described to you by Ms Golightly, that the powers under the Social Security Administration Act were used to obtain information from banks and information from employers. That is, notices were issued which required responses in the investigation and calculation of debts.
I've since become aware of that. Yes, I did know though. I did note that previously, that's what Centrelink officers did in practice.
Thank you. While we're in this folder, can I take you to tab 175, exhibit 4723? Commissioner, I note the time. This is my third last topic, and I'm not confident I'll finish by 5, but I think by 5:30.
Sure.
Now, Mr. Tudge, in July of 2017, another suicide was brought to your attention.
This is 175.
175, exhibit 4723. You see at the bottom of the page the email from Jason Stott to the Secretary, Ms Campbell, the Deputy Secretary, Ms Golightly, to your Chief of Staff, and then a number of people were copied in.
Yes.
And the subject was extremely sensitive. A DHS recipient took their own life, allegedly in response to an employment income confirmation letter. The Minister's office has been advised. The pause there, of course, your Chief of Staff, Mr Aston, who is copied in to this letter, would have undoubtedly informed you of this fact, given the keen interest you had in the program.
I can't recall, but he probably did.
Yes. Would there be any...
I would have expected him to do so.
You can't contemplate any circumstances in which Mr Aston would not have informed you of this matter that has been taken directly to the Secretary and Deputy Secretary and your Chief of Staff?
Not when there was a suggestion as articulated in the last bullet point on that page.
Were you aware of the other grim detail of it, which was that if anybody had looked at this person's file, they'd have seen an employment separation certificate which would have established that she actually wasn't employed at the same time she was getting benefit? I'm looking at the next attachment.
Yeah, so...
Unfortunately, as Ms Golightly pointed out, automation didn't provide for looking at employment separation certificates.
No, and I can't recall the details of this, Commissioner, but I do note that tragically it says here that this person took their life after the initial letter and the reminder letter. So before a debt was actually raised. And by that stage, a debt would only have been raised if a compliance officer did examine the file. And had that occurred, I think you're right that would have been identified, the issue you're talking about. I think this would have occurred under the old scheme as well if the data matching in fact did show this, because it would not have picked it up either, arguably.
All right.
I'll take you to some of the detail, Mr Tudge, but this was an employment information confirmation program. Yes. That is, after the refinements were made in February 2017 that you said solved the problem of separation certificates, and she in fact spoke to a compliance officer before the initial letter, or following the initial letter.
Right.
I'll take you to it. But you ordered an investigation in respect of the article relating to Mr Corso's death published in the Saturday paper. You didn't order an investigation in respect of this matter, correct?
I honestly can't recall the details of this matter. I'd have to be taken through to try to recollect my memory.
I'll take you through it, and I'll ask you the question again.
Maybe you can come back to that, yeah.
The suggestion I will make to you at the end, when we've exhausted the three documents which appear in sequence here, is that the reason you didn't order an investigation was because you were confident that it wouldn't hit the media and you didn't have to provide a public response.
I appreciate you saying that, Mr Gregory, and I'll no doubt disagree with that conclusion when we get to that point.
You can see from the bottom of the page the reminder letter was 20 June 2017.
Sorry, we're still looking at 175?
Yes, just in terms of the sequence.
Yes. Yep.
And the suicide occurred 5 days later, 20 June 2017. Yes. As we will come to see, the reminder letter being sent on 20 June 2017 might not have reached the person until much closer to the 25th because it was sent by registered mail. But you will also appreciate from what appears above this is that the recommendation from Ms Golightly was that contact should be made with the sister to offer social worker support.
Yes.
And if we go over to the next page, just going back in time to complete the dot points, you'll see that although there was no vulnerability indicator, the recipient had previously sought support from a departmental social worker and had provided medical certificates for mental health issues. This is plainly someone who falls into the category of a person with vulnerabilities which are known to the department before a debt is raised, before a discrepancy letter is sent.
Yes.
Right. Take you then to the next tab, 176, Exhibit 4724. And in sequence, you will see the email from Ms McCann from the department to Mr Storen relating to the person.
Is this in relation to the same individual?
Yes.
Yeah.
You'll see a note there that the person advised that she understood, that is the sister of the deceased, understood that the dates in the EIC letter and the dates from the employer separation certificate were different by 6 days.
Mm-hmm.
She offered feedback to consider for future reviews that when the department receives information from the ATO, we should check for employment separation certificates, and if there is one, contact the employer to check the dates. The person also suggested requests such as an EIC letter for such discrepancies can be difficult for people with mental health issues as they are vulnerable recipients. You wouldn't argue with any of that, would you?
No, if it's a serious mental health issue, then, and this was known, then they should not be subject to any compliance review at all. That was understood. The Ombudsman made recommendations to broaden the scope of that, and I recall, and there is some evidence in the materials that in fact I specifically said as well to the department that no person at all who has any indication of any vulnerability should be subject to compliance reviews. So I don't know why this person, looking at this detail from Ms McCain to Craig Storen, I'm sorry, I don't know if I'm supposed to mention the names, but
well, the explanation is a simple one, Mr Tudge. The generation of discrepancy letters was automated, subject to specific exclusionary criteria of official notifications of vulnerability.
No, but if there was a vulnerability indicator, they should not have been in receipt of it.
Yes, but that would require someone to look at the file, go through the history of it.
No.
Okay. Now,
that was part of the system.
The other part of what I read to you was that there should be a check for employment separation certificates. Now you told me earlier that was resolved after the specific issue was raised by Ms Taylor in January of that year.
So this is suggesting that occur before an initial letter be issued. What I was suggesting was that it was resolved that before a debt was raised, that a compliance officer would examine the file before a debt was raised.
What if someone didn't respond? How would that happen?
And then if someone didn't respond, then it would still be examined by a compliance officer, and the documents do suggest that.
So are you suggesting that what you required of the department and were satisfied was implemented was a manual review in every case before a debt was raised to check for an employment separation certificate?
I don't know the level of detail, but it's contained in the... There's 2 documents in the files there somewhere, and I don't know if they're in these folders or not, one of which was in about August 21st of 2017, which was a brief which came up to me for noting that the department would continue with income averaging, basically. And in that brief, it does note that no person would have a debt raised against them without a compliance officer looking at it. And I think it's further mentioned as evidence in the cabinet submission which Christian Porter and I put together in late 2017, I think in relation to about November, where it makes that point as well. So my understanding would be that that compliance officer would therefore be able to check that file and actually see this before a debt was issued. That would not pick up this case though, Mr Gregory, because this case was done on the basis of the data matching at the front end rather than at the end of raising a debt, having given the opportunity to the recipients to respond.
The distinction you seem to be making is that it might be more distressing to receive the debt letter than it would to receive the discrepancy letter.
Absolutely. I would assume so.
Why do you assume that?
Because the discrepancy letter, particularly after the letters have been carefully rewritten, carefully tested, very much said this is not a debt letter. There is a discrepancy of information. There may be an explanation for it, it says from memory.
It also says the debt may be raised.
Please contact the department in relation to explaining this. I think I would have to check the letter. It may well say that as well, but it specifically says, if my memory serves me correctly, this is not a debt letter and there may be an explanation for why there is a discrepancy. It was one of those things that I was very careful about ensuring was done. So I would suspect that the letter which this person received probably said along those lines. And I would say equally that that system of the data matching, that front end, hadn't materially changed for a long, long time.
Mr Tudge,
Now
this was a specific issue raised in January by an employee in response to something that Ms Campbell issued to the department, the issue of an employment separation certificate and the inability of compliance officers to go back and look at it.
Before a debt was raised. Is my understanding that you were raising it in that context? And I'd have to go back and look at that file, but that was my understanding of how you raised that.
And what had happened here was that there was an employment separation certificate on the file, and we'll come to it shortly, but a compliance officer was there, involved at that stage, and didn't look at it.
And this was at the stage of the first stage in the process, though. This is the distinction I'm making, Mr Gregory, which I think is a reasonable distinction, that you were at the beginning, in the January case, referring to the end of the process where a debt is being raised, and my point being that a compliance officer was reinserted into that stage to review the materials before a debt was raised. This case here, from my reading right now, as the first time I'm reading this, suggests that it's at the first stage.
I'm not sure I follow your logic, Mr Tudge. If your fix for the system, the automation of the system, was to insert a compliance officer at a stage in the process, and you say the best point was before the debt was raised and after the discrepancy was identified,
yes,
why wouldn't you do it at the start? Insert the compliance officer then to do the check so that all of the grief caused by discrepancy letters, the time, energy and cost involved in responding to them and discharging this reverse onus of proof was avoided. Why put the people through it?
Well, I can only reflect on why the Cabinet made that decision in 2015.
Mr Tudge, this was not a Cabinet decision in 2015, this was your fix in 2017.
With due respect, Mr Gregory, the essential issues which you raised then were Cabinet decisions of 2015, because it was putting the onus back onto the recipient, which enabled a lot more reviews to be undertaken. And my reading of the Cabinet minutes is that there was a desire to undertake more reviews because there was an identification that there was as much as 3.5% of the welfare expenditure, being $100 billion per year, was an overpayment. And yet up until that point, only a tiny fraction was reviewed. And in order to be able to do more reviews, the structure of the system had to change, and the Cabinet made that decision to change two key elements of the structure. One key element was to put more responsibility onto the recipient to collect that income information. And the second key structural element then was to create an online interface for the recipient to upload that information, both of which, those two things, enabled the additional compliance checks to be done. Without those two things, you could not do those additional compliance checks.
I understand your answer. Can you go to the top of the page? Mr. Storen responds to the Deputy Secretary. In terms of our review, there was a discrepancy in the data, therefore a review was triggered. It could have been resolved very quickly by the individual if she pointed out her employment ceased before the social welfare period. Similarly, it could have been resolved very quickly if the employment separation certificate that was on her record was accessed by the compliance officer and used to finalise the review. Neither of those things occurred, and we are looking at how we make that happen. Fortunately, the employment separation certificate is not structured data, so I can't see how we can include it in any automation. You can see that?
Yes.
Reading that now, and it being raised with you at the time, must have triggered deep concern in you that there were fundamental flaws in the delivery of the system apart from accuracy and legality.
Is there any other information that's clear that's what I received in these materials?
No, which is why I'm coming back to my point about you not ordering an investigation. The information which...
No, I'm just trying to understand, because I didn't receive this top half of the email that you're just referring to. That's...
Not in writing, according to...
Not in writing.
No.
No, so my information, and as I said, I don't recall this case, but I assume that my Chief of Staff would have informed me of this situation.
To use your language earlier today, in a different scenario, it is incomprehensible that he...
I don't think I used that language, but I believe he would have informed me.
All right.
I think you put that to me, but...
Can I take you then to the next document, 177, Exhibit 4725. The page contains a chronology in the bottom half and some observations in the top half. What is clear from the chronology is that Centrelink was in possession of information which demonstrated that there could be no possible debt which could have arisen. And yet, the reverse onus aspect of the scheme required a response to a discrepancy letter.
May I respond to that?
Yes.
I don't think your last characterisation was correct. I don't think it was the reverse onus which caused this. Because my reading of this, and I just scanned this now, is that, as I said, it was at the front end of the process where data matching had occurred and a letter was consequently generated from that data matching to say that there was a discrepancy. And in many cases that can be rectified. And even under the old scheme...
You're off topic, Mr. Tudge.
So, no,
Time is tight.
no, but it's not...
You're not answering my question.
But no, you put to me...
Discrepancy triggers the reverse onus.
No.
How not?
No, I don't think that's the case. The discrepancy in the past still triggered a letter to the recipients, and then that would be followed up if the recipient did not respond with a phone call to the recipient to say that there is a discrepancy. I will be now calling your employer and calling, if I need to, the bank to get that income information to determine what occurred with that discrepancy. And as the Ombudsman's report actually identifies, in 25% of cases in 2010, there was no such discrepancy having gone through that information. So my point is that didn't change, it wasn't to do with the reverse onus of proof that this came about. I'm not denying the tragic circumstances here, but it occurred at the front end of the process, Mr. Gregory, rather than at the back end where a debt was being raised.
But on your own account, previously, if there was a discrepancy, the client would be let know, the recipient would be let know and informed that the compliance officer would now go looking for the evidence for them. They would go to the employers or the bank. Now there's a discrepancy, explain yourself.
I'd have to go back and look at the precise letters, that the first letter that a person got even under the old scheme commissioner. Certainly going back, there's a letter in my attachments, goes back to 1994, and the 1994 letter has very similar language to the letters which are used today, which effectively says there's a discrepancy, you need to provide information to us, and if you don't, the ATO will use ATO data. That's in one of my attachments. I think it's already an exhibit. So certainly back then, and I understand that was the case going through as well.
I don't know why you understand it was the case going through, because all the evidence we've heard from people who worked in DHS was that the usual course was to go to the employers. It was not to require the recipient to be explaining themselves. It was a situation where they went to the employers. If the employer couldn't come up with something and the recipient didn't volunteer something, then they would do this last resort thing of averaging. But it was not a letter. The 1994 letters I've seen, but I have never seen any other letter over the entire 20 years up to the inception of Robodebt which reflected that.
No, and to be clear, I've never requested to see those letters. It was just my understanding that that was the case. That I knew that in the old system still that the recipient was asked for the information. They didn't have the information. Then the Centrelink officer, was my understanding, would undertake that work. So my point being that my understanding was that the data matching process didn't have the compliance officer involved in the data matching process at the start, checking before even triggered a data match. The reason why I say that in part is from the Ombudsman's report that in 25% of cases in 2011 that the discrepancy disappeared following the engagement with the recipient and following the collection of some information. So that's my understanding anyway, Commissioner.
Mr. Tudge, you gave evidence earlier that the Cabinet implemented two key changes in order for this system to operate, and one was the transfer of obligations onto the recipient to demonstrate that they didn't have a debt. Now, the point at which that was implemented in practice was when a discrepancy letter was sent asking for an explanation for the debt.
Yes.
And so what happened here in this case was that the discrepancy letter was the practical application of the reversal of the onus.
And I'm not trying to be argumentative with you, Mr. Gregory, in terms of what you're putting to me, but the onus came about because the discrepancy would be identified and then it was requested of the recipient to provide evidence to confirm or explain the discrepancy.
I don't think you've said anything which disagrees with the fact that the letter triggers the obligation to provide evidence that a debt is not owed.
The letter does, well, the letter does trigger a requirement for the recipients to engage based on the discrepancy which is identified, but it clearly states that it may not be a debt, is my recollection.
Now, if you look at the chronology, you will see from the information on file, 12 October 2015, the person submitted a New Start claim. 23 October 2015, the person provided an employee separation certificate which confirmed that she ceased employment on 30 September 2015. And then on 26 October 2015, the New Start claim was granted and backdated to the date that she submitted the New Start claim online, 12 October 2015. I pause there. You would accept that the department was in possession of evidence which clearly demonstrated that no possible debt could arise in respect of the payment of New Start from 12 October 2015. Simple chronology, the first 3 points.
Yeah, sorry, I'm just... the first 3 points in this chronological history.
Yes.
And your point, it doesn't say if she has any other employment, which I don't know in these facts, but if that was the only employment that she had, and then she was submitting a New Start and received New Start on that basis and had no other job, then it appears that she should have been in receipt of the New Start that she was entitled to based on the fortnightly income and the assets which she had available at the time.
Yes. She could not have been overpaid a New Start because she was paid after she stopped work. There was no overlap.
I know what you are saying. Conceivably, there may have been another job that she had which she had not declared, but I'm not... Your point, I'd be guessing at that point, but you're pointing to me that it's unequivocal. It's not unequivocal, but it's likely on these facts. And if she had certainly had no other employment, no other income, then absolutely she was entitled to this and would not have been overpaid.
You'd reasonably expect in a detailed history of a sensitive case, if there'd been some other job, they'd have mentioned it.
I would think so, Commissioner. I'm just reading this for the first time, so I'm...
Okay.
Well, Mr Tudge, you've seen the response of Craig Storen. It could have been easily solved if the employment separation certificate on her record was accessed by the compliance officer.
Yep.
You've got people in the department at a senior level identifying a very simple point which solves the problem. It is beyond doubt that she could not have had a debt.
On the facts that are here, it appears that she did not have a debt.
And on the assessment of the department once it was escalated.
And on that assessment, based on those facts and based on that assessment, it appears that she should not have had a debt.
We continue the chronology. A month after her New Start was granted and backdated, she contacted DHS to discuss financial hardship. She was referred to a free legal company for advice on the early release of superannuation, and she informed the department through the social worker that she suffered workplace bullying and is seeing a psychologist. You see that?
Yes.
Now there's clear indication to the department that this person is vulnerable.
Yes.
Well, she gets New Start on the basis of recurring depression, psychiatric disorder, and so on.
and it's not clear whether this is on her file, Commissioner, as to whether or not there's a at that stage that the.
I'm looking at, to support her New Start allowance, she provided medical evidence of recurring depression, psychiatric disorder,
Right.
personality disorder.
In which case,
anxiety.
that should have been listed then as a vulnerability on her file, and then not subject to any compliance initiative.
I've been asked to request the document be taken down, and you can look at the hard copy in front of you, Mr. Tudge. Can you, given your intense focus on the scheme in January and February of 2017, explain why she was sent a discrepancy letter under the EIC part of Robodebt?
I can't fully explain that. My judgment, based on the information which you've presented to me, is that there was an error in not having a vulnerability indicator on her file, and if there was such a vulnerability indicator, she would not have received a compliance letter suggesting that there was a discrepancy.
We move then to the 2nd of June 2017. The EIC letter is sent to her. You'll see from the chronology. Because of the ATO match or identification of a discrepancy between income earned in the 15-16 financial year and the income reported on departmental records. Do you see that?
The 27th of the 6th, yes.
2nd of the 6th, 2017.
Yes, sorry.
And you can see what is recorded there in terms of ATO information.
Yep.
Is that there was approximately $12,000 of income,
yeah,
period 1 July
yes,
2015 to 18 October 2015,
yes,
which was what the employer would have reported to the ATO.
yes.
Right. But the department knew from its own records, or was capable of knowing from its own records, that the date 18 October 2015 was an error by the employer, because the employment separation certificate confirmed that she finished work on the 30th of September 2015.
Yes.
And as is observed in the chronology, recipient would contact the employer for additional documents. Now, in the context of the reverse onus, the recipient was obliged to demonstrate that there was no discrepancy, and generally that was done by way of pay slips or bank records.
Sorry, in terms of, you asked me about the last bit. It's generally by payslips or bank records, yes.
Except in this case, the person for whom she had to go for additional documents, namely the employer, related to the fact that she had stopped work after suffering workplace bullying and was seeing a psychologist, and was granted an income support supplement for depression, psychiatric disorder, personality disorder and temporary anxiety. Now, it ought to have been obvious to the compliance officer at that point, asking her to go back to the place where she suffered a psychological injury, and to get documents to prove that she wasn't overpaid ought not to have been done.
Then there's 2 points here. One is that, in fact, 3 points. One is that she should not have received a letter in the first place because there should have been a vulnerability indicator put on her file. Yes. And there was an error which occurred there. I think second, even when a compliance officer became aware of the reasons for her receiving New Start, which include having a psychiatric illness, there was a second opportunity for a vulnerability indicator to be placed on and for that compliance activity to be ceased. And the third point I'd say, Mr Gregory, is that compliance officer should have said, please don't go to your employer. We've changed the system so that you can enter your records directly from your bank statements. Your bank statements are typically all available. They legally are available for at least 6 years. And typically you can get them online in nearly all cases.
I suggest a fourth point, which I identified earlier, that there was a flaw in the system by the fact that she was even sent a letter of this nature.
And that if there is a flaw in the system because the system, I think your suggestion that there was a flaw because there wasn't not a individual who was looking over the files before a discrepancy letter went out, or as a flaw in the system because the IT system, which was doing the data matching, was not capable of picking up the fact that that person had finished her employment as evidenced by the separation letter, separation certificate.
You agree those are flaws?
I think that's what you're putting to me, aren't you, that it was the flaw because of one of those two reasons?
Well, there may be a third, but what do you say to those two?
Ideally, that the system would pick up the separation certificate, absolutely.
Yes.
And
particularly given that the issue of separation certificates had been raised in January as an issue by compliance officers.
Yes, and you are correct that ideally that system would incorporate those separation certificates, as I said, right at the get-go, but the fact that they didn't, they would be picked up, obviously, and I know we've been through this and I'm not meaning to relitigate this, Mr Gregory, but it would have been picked up subsequently in reviewing the file before raising any debts.
Well, you say they would have been, but it in fact wasn't when a person looked at it.
It wasn't here. Well, the debt wasn't.
What you mean is should have been?
I don't think it got what I was referring to in January, which is what I understood the compliance officer was raising, was at the raising of the debt stage. And I know that we had our disagreements in terms of that, but that's what I understood was being raised in the January situation, that before a debt had been raised, which is largely been the subject of most of the discussion of this Royal Commission, that there be a compliance officer who would be able to check the file before a debt was raised.
Mr Tudge, you would not be assisted, I think, by trying to identify what's been the focus of the Commission. I'm asking you a particular question, and it relates to the relevance of employment separation certificates to the raising of a debt. And you are saying that's a very confined point in time of the process. Surely in January 2017, your communications with Catherine Campbell or Melissa Golightly in respect of the employment separation certificate sought to enhance the system by ensuring that where that information was on the file, people were not put to the time and expense of having to justify they didn't have a debt. Surely that was an enhancement to the system you talked about in that specific context.
I don't recall us talking about that particular enhancement at that particular point in time. And there's lists, obviously, of the enhancements which we made, including in the letter which we're just discussing from Minister Porter and myself to the Prime Minister, as well as in the Ombudsman's report. And that doesn't include that. When you put it to me now, I think ideally that I think you're right that we should have made sure that the IT systems, I'm not sure how complex that would be, could pick up a separation certificate.
I think Mr Storen was pretty clear they couldn't. This illustrates another problem with this, doesn't it? That you're putting people at the mercy of employers' precision as to dates in a context where the employer's under no obligation to give anything more than a financial year period for employment. So the odds are against the employment period being correctly stated, but on the strength of that inaccurate piece of information, you're going to make people go and find the evidence to justify their position.
And it's why, as I said, within my authority, I was particularly keen to make it easy for people to find that evidence, and particularly through getting bank statements, Commissioner, and being able to enter your net income figure rather than your gross income figure. And bank statements were available, typically available online, and which means that they were, in most cases, at people's fingertips to be able to enter into. And that's what I was particularly focused on.
I think you're talking about a very computer literate class of recipient.
And
might work for the youth allowance people, the students, but there's a whole body of people who may not even have access to a computer, let alone to online bank statements, let alone have the sort of account where they're looking at it online.
no, but well, and alternatively, they of course could go into the bank themselves and get their bank statements from the bank.
And we've been hearing about people not being able to afford it, being charged.
And the banks did have hardship provisions. I mean, in most cases, and I recall looking at this question, that in most cases you could get your bank records for free, certainly from most of the major banks, and that there were hardship provisions. And if my recollection serves me correctly, the department started to work closely with those banks as well to ensure that they were making them available to people. That was absolutely one of my focal points, to ensure that it was as simple an exercise as possible for a recipient.
Mr Tudge, I'll take you over to the last page of the document. Of course, you'll see at the bottom of the page, just before you turn it over, that the person who contacted the department advised that the recipient had passed away shortly after receiving the employment income confirmation letter. And then provided some further information at the top of the next page. Relevantly, that the person, the recipient, went through an unfair dismissal process with her former employer, and that it's possible the letter could have impacted her mental health and brought back memories of the issues she experienced. And the third dot point was, this could have been easy for someone who is not vulnerable, but the thought of speaking to the previous employer may have been daunting and overwhelming for her. You see that? On the information that has been produced and by the department in respect of this, those three documents that I've taken you to,
Yes.
while it's not possible to say that the Robodebt scheme was the cause of the suicide, it's equally not possible for you to say, as the Minister, when this occurred, that it was not. That's right?
Well, I'll just say yes.
And that for that reason, it is possible that had the system at least had the capacity to deal with the issue of employment separation certificates and avoid putting people through the difficulty, this death might have been avoided.
I appreciate you saying that, Mr. Gregory, and we simply don't know. We simply don't know.
Yes. Having gone through that detail, do you now recall whether you asked for an investigation of a file which appears to involve repeated errors, both systemic and personal?
So, and I was asking you before because I don't recall this case, as to what documents were presented to me. And I think you indicated that there weren't documents that were presented to me, that there was an email that was sent to my Chief of Staff of an abbreviated email, and that I assume that he would have informed me about it. My assumption is that he would have informed me about it verbally, and to say that this had occurred, he probably pointed out that I think was available in that email, I can't recall the tab number, that it wasn't I'd have to go back to the email to sort of try to understand that, and he may be able to reflect in terms of the conversation that he had with me, because I can't recall that conversation.
Reasonable also for you to assume that you would have said, that's serious, keep me updated.
Yes.
And I want to report back on the extent of what happened.
I just can't recall, and it depends on...
I'm asking you what it's reasonable to assume, because that was your answer.
Can you refer back to the email?
3 tabs earlier.
3 tabs earlier.
Tab 175.
So I'm just looking at here that Andrew has asked for an update at the end of day today. I don't know if there's evidence of an update which was provided. I mean, the key thing, and I don't know whether Mr. Aston raised this with me here, but the key thing that I particularly see is that that there's no vulnerability indicator on the recipient's record, despite the bullet points saying that she'd previously sought support and had medical certificates for a mental health issue. I simply can't recall, Mr. Gregory, what was raised to me.
Yes, I didn't ask you to recall. We had been through your recollection.
Yeah.
I was asking you whether it was safe to assume that you would have asked for an update, given there could be a connection between the receipt of the letters and the suicide. Or would you not have been troubled to get an update?
Looking at this, my Chief of Staff has asked for an update. He may well have been waiting for that update to inform me, and particularly given that the email that I see is sent on Friday. The Friday is typically the day when I'm not doing ministerial work, that I'm actually in my electorate office.
It doesn't stop you getting an update.
It doesn't stop me getting an update, and I would still assume that having got further information that he would have updated me, but I just can't recall. And I don't know what information he had other than what's here to be able to update me on. But certainly,
it is a matter
reading the details, it is a very concerning case, reading the details as you've put to me today.
Well, the suggestion that there was a suicide-related to letters, receipt of letters, of itself is a very serious suggestion.
Absolutely.
And you would, as Minister, have been deeply concerned about that, I suggest.
Yes, absolutely.
You can't recall the case now, I appreciate, but is that because there were lots of suicides that you were being told about?
I don't know if there was lots, but I do know. I do know from the DHS annual reports that there are at least 5,000 or about 5,000 instances a year where social workers were engaged because of threats of suicide, unfortunately. So it was not a. Sadly, it was common for Centrelink officers to have to deal with people who.
But threats of suicide don't get escalated to your office, do they? You read about them in an annual report.
I can't recall. I don't know. Some may well do, but I can't recall, Mr. Gregory. This has been elevated to my office in the form of an email, but not in the form of any other formal document as such. Unlike, I think, the previous case that we're referring to.
In the form of an urgent and extremely sensitive email.
Extremely sensitive in terms of the information which is being contained within that, and that's all. And it is very sensitive information, and it's almost in terms of, is it a confidential document, is it a cabinet document, is it a very sensitive document? This is a very sensitive document with a person's name and reflecting on the fact that they did commit suicide.
Mr. Gregory, I no longer believe in your promise of finishing by 5:30. Now, will you finish by 6? And if so, we'd better stop for 5 minutes again for the transcribers because it's a couple of hours since I had that last break.
Can I just have one moment? I doubt my own estimates at this time of the day, Commissioner.
You doubt what, sorry?
My own estimates of time at this point.
So what do you want to do?
I think it is best if we conclude for the day and I resume tomorrow.
I don't know if you had overnight accommodation booked, Mr. Porter, but I feel there's somewhere
Tudge.
in this town you can find a room. So do you want to start at 9:30 just to get underway a little faster?
Yes.
Yes. Does that suit you all right, Mr. Solomon, mainly, I suppose? Mr. Go, do you have...
It will have to. We'll make it work.
That's probably about right. Ms. Hogan-Doran, you're always accommodating, so...
No difficulty, Commissioner.
Thank you. 9:30 tomorrow, then.
All rise. The Commission stands adjourned until 9:30 a.m. tomorrow.